ready the paper book.
Paperwork business is stopped. You take in the pen drive and do it.
Lordship,
May I please, Lordship?
Lordship,
Item 108.
but
You can take it. Yes.
Lordship,
Lordship.
item 108.
Lordship,
We have already filed a withdrawal memo that has been already reflected.
108.
Item 44,
Obliged.
but
item 44, my lord. Let come any other day, my lord.
44.
44, my lord. In the meantime, I'll take instructions from my clients, my lord.
Is there a stay?
No, no, yes, my lord.
but I pray Lordship, your Lordship may direct to ready the paper book.
I told you get the pen drive and no direction is required. You come and do the pen drive, take it. Whatever you want.
Item number 73, my lord. Case 302, a regular bail application. I have to obtain to evidence witness
On request. Yes.
well, next week.
We don't know. When you are asking adjournment, we need to go according to.
Let it go, because the evidences.
So whatever, because maybe once it is listed, you argue. If you are asking adjournment, we have to adjust our time. Yes.
Well, this is a 482 application which has been moved before your lordships, and FIR has been lodged. Your lordships would remember. There's a second FIR being lodged against the MD of OPG.
I don't remember anything.
Well, your lordships have seized of the matter. I am being led by Mr. Parija in this matter. If your lordships can post it to 19th or 20th, it was listed as item 117 on Friday. It couldn't reach.
Friday, we adjust.
Any day on 19th or 20th.
We'll adjust.
I'm great.
Yes. Yes. Is there any mentioning, sir? Is he mentioning item 2? The seat. Are you mentioning anything?
Yes, my lords. Actually, there is a matter, my lord. Criminal revision 172 of 23. Your lordships have. It's not on. It's on board. It's on board. Today it is not on board, my lords. That vigilance case, my lords, we have been pursuing for so long. Your lordships will fix up any day and let the matter be disposed of, because the officers are one has already retired. The other person is about to retire. Only the vigilance has to answer.
Okay, I'll see that we'll adjust.
Yes, my lords. Any date at 2 o'clock, my lords.
Yes.
Or any time convenient to your lordship.
Yeah.
Obliged.
31. Hearing. I think Lordship, one day, hearing day, in a week, one day, hearing day.
It's easy for you to tell. Every day, hundreds of bail matter. See, that's not a problem. I tried everything. It's not possible. 3 o'clock, you don't waste time mentioning half an hour. You mention 5 matters, I can dispose of. Better that keep quiet. I'll try and finish it up at 3 o'clock. Sometime I'll take it. Yes. Yes. 42. Yes. Yes. Where are they? Are they coming?
Yes, my lord.
Yes.
So far, one of the petitioner, my lord, the case has been quashed. Since he has accused. And other two, they have not appeared.
Where is that order?
Order dated 6/9/2024.
6/9?
24. Last Friday.
Last Friday. Okay. Okay, 16/20. Okay. And this is an counter petition submit that to one more opportunity should be given to the presence of petition number 2, 3, and 4. Huh? 2, 3, 4. Who are they? 2, 3, 4. This is the fresh petition you have filed.
No, same. That is
2, 3, 4. And who is Bharat Bhushan Rai? Okay. And Ajay Das? And Shambhunath Das? Tasmita Mohanty? Yes. Right. This matter, the same matter. Yes. This matter was taken up for hearing on 6/9/2020. Following order was passed. Following order was passed. Since petition number 2, 3, and 4 were not present in the court on that day, the the matter was adjourned. Matter was adjourned. The parties have settled their dispute. As has been mentioned in the earlier order. The petition number 1 and opposite party number 2 were present present before court on 6/9/2024. 24. Today, petition number 2, 3, and 4 are present, being represented by their counsel, and they file self-petition copies through their Aadhaar card to establish their identity, which is taken on that. Regarding head to the fact that the parties have settled their dispute, dispute and filed joint affidavit before the court.
And also the instruction from the IAC, Basdevpur, that the matter has been
And
completed.
instruction
Like High Court.
instruction furnished by IIC Basudevpur Police Station by its report dated 48/10/2022, the FIR and consequence of FIR IPC case, whatever is was. Okay.
43.
Yes.
My lord, the last occasion, my lord, directed the parties to be present, my lord. The matter relating to quashing of the criminal proceeding under the ground of compromise, and they have married each other, and
What are the offences?
my lord, the offenses.
372N, 417, 120B, 506, 34.
What is the age of the girl?
Age of the girl, my lords, on the date of the incident, my lords, 19 years, 5 months,
She
16
was
days.
major. She was major.
My lord.
They are married now.
Yes.
What is the affidavit?
Nikanama is also there at flag X on your lordship's file. And,
X.
yes. And the joint affidavit is at flag Y.
14/5/2024, your lordship passed an order, my lord, and telling that.
14
14/5/2024. 14/5/2024.
This which is this item? 43.
14/5/2024.
14/5. Okay.
Madam.
Delegation. Yes. Have you verified?
Verified, my lord.
Huh.
I have received, my lord, instruction from the IAC, my lord. Simulia. He stated that inquire about the marriage of SK Habibullah, 19 years, and the victim, my lord. Though the complainant SK, Nayabuddin, his present, my lord, came to PS, presented notary affidavit before me about the marriage of his daughter to the SK Habibullah, dated 16/5/2024, before under Haira police station. Both the family members of the victim and CICL made marriages by the time she was juvenile. By the time, my lord, make marriage affidavit under the notary public Soro. The marriage was solemnized in between them on 16/5/2024 as per the marriage affidavit document. Further, I proceeded to the village Raghunathpur and inquired that no such any neighbor of SK Habibullah petitioner can able to say about the marriage. The victim girl was in her paternal house as per the statement of father of the victim. I tried to contact the victim over the mobile phone in the presence of father, but in vain. At the time of occurrence date, birth of CICL SK Habibullah was 6/2/2005. That is 17 years or 7 months by the time of occurrence.
Marriage, whether marriage has taken place or not.
Marriage, notary marriage here.
Notary will not decide.
No marriage.
Where is Nikanama? Why are you not verifying the Nikanama?
Nikanama, my lord, so
Last occasion I have
they have given Nikanama.
Yes.
Huh?
Later on they have produced
Yes.
Nikanama.
Right on.
Nikanama not with
Right
me.
on. The matter was taken up for hearing on 14/5/2024. On that day, the state council was directed to seek instruction from the IIC Simulia police station regarding the marriage between the petitioner and
yes,
opposite party number 2.
original
Petitioner
interest.
and opposite party number 2. Petitioner number 1
Opposite number 2 মানে father,
Opposite-
opposite 3.
My lord, present.
3 the victim.
and the victim call and the victim call. IIC Simulia has given the instruction to the state council inter alia stating that on the basis of the affidavit, notary affidavit attested by a notary, he tried to ascertain the marriage between the petitioner and the victim. Subsequent thereto, the Nikanama has been this is Nikanama where it is
18
Municipal. Subsequent thereto, the petitioner has produced a Nikanama, certificate copy of the. How to take about this certificate copy can be used.
মানে after the order pass, thereafter my lord the Nikanama.
Now, will you verify it or I'll rely upon it and pass the order?
certified copy ଆଜ୍ଞା ଦଉଛୁ ଆଉ କଣ ହବ?
Subsequent thereto, the petitioner have placed on record the certificate copy of Nikanama. क्या लिखा है तुमने लिखा? सरकारी जल्दी विवाह Where are the names of the girl and boy?
names are mentioned here.
Huh?
Names are there.
Like,
Second page that's.
it is.
Second page ରେ ଅଛି।
Second page.
ଓଡ଼ିଆ
Sheikh Habibullah was 21 ବର୍ଷ।
The
First
petitioner has
Mahatma
submitted a hands up certificate copy of Nikanama dated 19/5/2024, which is taken on record. Taken on record. The matter was when the matter was taken up for hearing on when was that order? 14/5.
14/5.
Following order was passed.
Thereafter they got my Nikanama thereafter.
Following order was passed. The subsequent thereto, when is that order?
14/5 order pass my lord.
Huh?
Then thereafter on 18/5
Certificate copy. 14/5.
14/5 order. Thereafter my lord the Nikanama 18/5.
19/5.
19.
Subsequent to the aforementioned order, the the petitioner and the victim appears to have married on 19/5/2024.
मतलब देखिए 18/5
19
अरे 18/5
19/5.
No, my lords. Nika is done on 18/5. Certified copy date of delivery.
ना ना certificate 22/5/2024.
18.
हाँ मतलब 18 the later.
No. Certified copy.
Certificate copy is 22/5/2024.
हाँ 22/5 और Nikanama 18/5.
19/5/2024.
18/5
8 is side line लिखी each side.
तले फर्स्ट पेज तले लिखी 18/5 विवाह तारीख इंग्रजी डेट 18 मई 2024 सैटरडे
सेटा सर्टिफाइड कॉपी रो हेई नथिबो एटा सर्टिफाइड कॉपी रो जेरॉक्स एटा देखिबे देखन सेटा सर्टिफाइड कॉपी न पारे
Stated to be married on 18/5/2024.
हाँ सही
The certificate copy of Nikanama obtained on 22/5/2024 is placed on record. Placed on record. Placed on record. The petitioner number 1. Where is the girl? Petitioner number 1 and the victim. Who is he? Who is this man?
The man is the father informant.
Father of who?
Father of the victim informant.
Victim and victim girl and the father of the victim girl. Both are present in the court. They are represented by their respective counsel and identified with them. And they've also filed the self-attested copy of their Aadhaar card to establish their identity, which are taken on record. In view of the order dated 14/5/2024 and in view of the fact that the petitioner and the opposite party number, actually victim, have already married in, and Nikanama is placed on record. The marriage has been accepted by the families of both the parties. The case of the petitioner is directly covered by the judgment of this court in Rosalina, so and so, so and so. Hence, the petition deserves merit accordingly. This is past, yes. Next.
45.
Seeks one more adjournment to place on record the copy of charge sheet on adjournment matter. Yes, next.
46. You find out the plans of the petitioner is that the prayer on section 311 of CRPC was filed before the on a trial court and it was rejected.
Yes.
Your Lordship, the petitioner's prayer was to recall PW 3, 4, 6, 7, 8. By now, we got 19 witnesses were examined. And only the contradictions which are inadvertently not put to the investigator, not put to the.
Why have you not cross-examined, by the way?
My lord, the truth, what I have collected, that the not an advocate who was conducting the case, he was suffering for a long time and subsequently died.
You have asked to, you have moved an application for recalling of 5 witnesses.
My lord,
You select how many you want.
my lord,
I will not rock, stock and barrel, I can't call everybody.
Your Lordship may kindly see the only.
I will not see, you tell me which witness is very essential for you. I'll allow that.
PW 4, PW 7, PW 8. PW 7 one line, PW 8 one line.
No, forget about line. You have got full opportunity to cross-examine. That is the case.
My lord,
Still, you now the change of counsel and you wanted to be wiser.
your Lordship
confront this.
kindly appreciate only the contradiction. But there is no intention of the accused to linger the case or to develop a new story. Only the contradiction. That he has not stated.
No, what you will ask, you have not written that also in the application. I don't know what kind of application.
So, my lord, PW 4 and 7, at least 2 witnesses out of 5. PW 4 is most important because it's a 302.
Where is your application? You are
My lord, my application is at page.
see, the application is so vague, so vague. Who will allow this kind of
Page 16.
now you tell me who will allow this kind of application?
My lord, with great respect, your Lordship, lower court, frank court advocates and it is a junior advocate, what I am not.
What is this application? Just see. Who in the earth will allow this application? You tell me.
As far
What kind of application?
to the best of his knowledge, he has indicated in the petition. Your Lordship, may excuse this.
5 witnesses. Which 5 witnesses?
My lord, it may be limited to at least 2, 3.
That's what I'm asking. Which 5 witnesses in the application doesn't disclose which 5 applicants?
My lord, in the petition, your Lordship, he has categorically.
PW 3,
Uh,
3, 6, 7.
3, my lord, 4.
Where in the application? Where have you said?
Application, my lord,
3, 4.
PW 4, PW 6, PW 7, and PW 8. 4 names.
1, 2.
Second paragraph. 4, 7, 8.
3,
Second
4.
paragraph, second line. And then.
Anybody in the prayer he writes 5 witnesses.
My lord. PW 4, PW 6, PW 7 and
See,
8.
3, 4, 6,
My lord.
7, 8.
8.
Okay. Take it. And you want to
My lord, 4, 7, 8.
4, 7, 8.
Single.
3021, right out.
Single.
Petitioner is agreed by the order dated 26/11/2022, passed by the additional sessions judge Kamakhya in CT sessions case number 4 of 2019, whereby his application under section 311 CRPC seeking recall of 5 prosecution witness, namely PW 3, 4, 6, 7, and 8 has been turned down. Although the application although the application under section 311 CRPC moved by the petitioner is cryptic, and cryptic and divorce of any particulars. But the fact remains that the petitioner is facing the trial for offence under section 302 IPC, and he has a indefensible right to defend himself, defends himself. Therefore, the right to defend. The counsel for the petitioner submits that the counsel who was appearing for the accused persons have expired, huh?
Counsel, Mr. Mishra.
Has expired. Therefore, the appropriate expired. Therefore, the witnesses could not be confronted with certain questions. Hence, he seeks indulgence of this court and submits that at least 3 witnesses, namely PW3,
478.
478 should be recalled so that the witnesses could be confronted. Regard being head to the fact that the petitioner is facing the trial for an heinous crime, he has a indefensible right to defend himself. I am inclined to allow the prayer of the petitioner and direct the trial court to recall 3 witnesses, namely PW4, 7 and 8, for subjecting them to cross-examination on a particular date to be fixed by the trial court. It is made clear that the petitioner shall not seek adjournment on the date fixed by the trial court. The petitioner shall conduct the cross-examination of these 3 witnesses. And before cross-examination, you questionnaires is not you want to confront.
My lord, only confrontation, sir.
So questions are not required. It is made clear that on single opportunity is provided to the petitioners to cross-examine these witnesses. No further adjournment shall be sought by the petitioner before the trial court on any context whatever.
Yes, sir.
With this observation, the petitioner is disposed of. Yes. Yes.
47.
Pardon me, Lordship, I am appearing in item 47.
Yes.
Lordship, in the first item, CRL REV 770 of 2018.
How many matters are there?
Two matters.
Two matters.
Okay.
Two matters are there,
Yes.
Lordship. In the
Yes,
first item, Your Lordship, the conducting counsel had expired last year, Your Lordship. And last year, the conducting counsel expired, Mr. Siddheshwar Mahanti. And second, in the last occasion, Your Lordship, when the notice was issued, Vigilance Department took time to collect instruction. And till now, they have not filed any reply to this matter.
What is this matter is about?
I have challenged the rejection of a discharge petition, Your Lordship, in this matter.
And there is no stay operating?
No, Your Lordship. And the trial has not commenced till yet. What instruction I have?
2018 is the order. Now we are in 2024.
24, Lordship.
We don't know whether the trial has proceeded or not.
No, Your Lordship. The trial has not commenced as this matter is pending before this Honorable Court. So the trial has not commenced till yet. So, Lordship, I pray if they want to file a reply, they could, or otherwise the matter could be put up for a final hearing, Your Lordship.
Mr. Mahapatra, Land Counsel for the petitioner, seeks an adjournment on the leaves the matter for final disposal. The good date the final disposal.
Let's say another matter is criminal revision 703 of 2018. Let's see.
Second matter,
Yes.
yes.
There is an interim order. Let's see.
In both the matters, there are no interim order.
Yes.
This matter is the interim order. Let's see. Last.
Interim order is there.
Let's see. Interim order.
Because of this interim order, you are just simply asking for adjournment. Where is that interim order? Yes, in the corrected matter, there is an interim order. Therefore, the trial is not proceeding.
Yes, Lordship. I have no idea about that status
Let's see.
of
There is an
the
interim
other
order
matter.
last.
No, you argue what is this matter?
Lordship, I don't have the brief right now with me, so
Yes,
this
tell me, what is this matter is about?
Vigilance matter.
Vigilance. Pass it over.
Let's pass.
No, there is an interim order. I don't want to adjourn it. Let us see what is this matter. Okay, pass over. Yes. 48.
Item 48 may kindly pass over, your lordship,
Possible.
on behalf of BF.
May reach, may not reach, okay. Let us see. 40, bail matter, 49. Please, yes, sir. Yes.
Lords, here, your lordship has heard this matter. I am the husband against whom allegation was made of having been
Have you
in-
received the instruction?
My instruction.
Yes.
Second adjourned session judge, Puri,
Ah.
total 25 PWs are there. In this case, so far 7 PWs have been examined.
Hmm.
The complainant Manu Dasa has not been examined on the PO has been transferred since 1/8/2024. New PO has not yet joined. After joining of the new PO.
You are in custody since?
I am in custody, my lord, since the date of incident, 23/6/2023,
23/6/23.
my lords.
Okay.
Now, Manoranjan Das statement, his and his wife's, they don't disclose that I was present there.
Yes.
So that's why, my lord, I said that this is a case where there is
Samir
nothing to
That's
show that I was present. He has slipped from the stairs, my lords, and sustained injuries.
Yes. What are the evidence?
Allegations matter so far the Manoranjan is concerned, my lord.
No, he is
Lord.
Samiran.
Ah.
Snigdha Sahu.
I,
What is the allegation against this girl? Who is she, by the way?
he is the husband,
Husband.
Who?
the petitioner.
Acha,
Petitioner
Samiran.
is the husband of the deceased.
Acha.
Deceased sustained injuries and died on.
This is
21
the Snigdha.
Yes,
basically.
no.
How?
The petitioner
Why
is
this
Samiran
Bhag-
Singh.
Bhagesri.
Why
Wife is
his name?
Bhagyasri.
Why this name Snigdha?
Snigdha.
Samiran or Snigdha?
Samiran or Snigdha.
Snigdha.
Snigdho.
I-
Snigdha likhe. Anyway.
My lord, what happened in this case, my lord?
Hmm.
The father of the victim, my lord, the deceased, my lord, relevant person ପଡୁଛି ବାରମ୍ବାର ଆମ ଜ୍ୱାଇଁ ସମୀରଣ ମୋ ଝିଅ ଭାଗସ୍ୟ କୌଣସି
Head injury on the back side of the head.
charge my lord. I will mention while something charge after the departure of Samiran started argument with Bhagesri as she intimated the fact to her parents. Even who went to the extent of assault to Bhagesri in form of fist blow and kick blows. Out of anger, he pushed Bhagesri, as a result of which she fell down on the edge of a staircase and sustained head injury on the backside of her head. Subsequently, he compressed the neck of Bhagesri and also compressed the
କୋଉ
nasal
ଏଇଟା
area.
ଏଇଟା କୋଉ evidence ର
Result
The medical report suggests that.
medical report I placed before your lordship.
I seen it. And who all are, how many witnesses are there now?
7 witnesses are only, my lord,
Examined.
examined.
And all vital witnesses have been examined.
Since my lord PO has been transferred, my lord. No new PO one not happened.
Lords may see what is the injury report. I am placing all those injuries.
6 months, huh? 6 months. 6
Lords
months.
may see the injuries. Contusion on the left parietal eminence. Contusion over the right parietal eminence. Abrasions on the right ear pinna lobule. Bruise on the right and mid part of the inner side of upper lip of the mouth. Abrasion on the right side of lower lip. Bruise on the right side inner aspect, lower lip of mouth.
She was assaulted, it looks like. Severely assaulted.
Where is that evidence that I was there?
She was in your company, you are the husband.
There is no evidence that I was there at that time.
So it is presumed that you are the husband, you were there. And the charge sheet says that you have pushed him.
On what basis, my lords? Is there any witness who has said so?
There may not be a witness, but these are the circumstances. See, the problem is it was so unpleasant. The father of the petitioner himself has committed
day
suicide.
in and day out.
Committed
the apex
suicide
court is-
because of the-
apex court day in and day out is saying that one should not be detained in custody as a measure of punishment. My further submission, if this is the allegation, neither Sony was charge sheeted nor my mother was charge sheeted. How on that?
That's right.
basis
Therefore, I am giving 6 months. 6 months, you renew the bail plea of otherwise. How many witnesses are there total?
Total, my lord, total, 25 witnesses.
Vital material witnesses?
everybody will be material now.
The family member,
There is nobody here who has seen it.
Some of the
Everybody is
neighbors,
waiting.
my lord. Some of the neighbors are examined, my lord. The family members and some of the neighbors.
And these evidences were recorded subsequent to the rejection of the bail application.
My lord.
Which evidence?
these PW 2 to 7.
No, this is the first time I am coming up for bail.
Rejection for.
After rejection, all these things are there. Right. The petitioner is agreed by the order dated 19/10/2023, passed by the trial court, Sessions Judge Puri in BA number 159 of oblique 773 of 2023, whereby the bail plea of the petitioner has been rejected. Subsequent thereto, couple of witnesses have been examined by the prosecution. For prosecution, there are 25 witnesses.
None of whom have implicated me, your lordship may say.
Cited in the charge sheet. Mr. Hon'Ble, learned counsel for the petitioner, submits that although the prime allegation is that the petitioner was having an affair with one lady who was initially mentioned in the charge sheet.
No, named in the FIR.
Named in the FIR, but subsequent thereto, in the but however, after investigation, charge sheet has neither been filed.
That has been found to be false.
Against the
Your lordship may say that it has been found to be
against
false.
the lady as well as the mother of the petitioner. The investigation reveals that the allegation of extramarital relationship by the petitioner found to be untrue. I have perused the medical evidence. The medical evidence reveals that the victim has received multiple injuries, and it appears that the charge sheet is also discloses that the victim, the petitioner has pushed the victim, as a result of which she fell down and received head injury, and subsequently she succumbed to the injury. In view of the aforementioned, I am not inclined to enlarge the petitioner on bail. However, liberty is granted to the petitioner to renew his bail plea before the court below, as subsequent to the rejection of the bail plea, other materials have already come on record. The trial court shall decide the bail application within 15 days by taking into consideration the material available on record. With this observation, the petition is disposed.
Well, I am told that the trial court is transferred, my lord.
If the learned Mr. Ragda, learned counsel for the petitioner, state submits that since the presiding officer,
1/8/2024, we are transferred.
the presiding officer has already been transferred on
1/8/2024.
1/8/24. The
New PO has not been
the new officer has not yet assumed the charges. If the application is moved, the same shall be considered by the learned sessions judge, district and sessions judge. Yes.
Urgent copy.
Yes. Huh?
Pass over.
Pass over today, don't ask. 102 matters, what? Bail matter pass out. Okay, pass out.
51.
Pass over.
To submit me, lord.
51. 51.
50 pass over.
Why are you not coming with preparation? Bail matter, why can't you do yourself? I am passing it over, you have to do it. Otherwise, I'll adjourn it to November. Yes.
What happened, my lord?
Yes. 51.
Instruction I have received 50.
50, okay, 50. 1 minute.
Regarding the status of the trial of the case, my lord, that's why earlier asked me, but the question regarding status of the case, my lord. Out of 43 PWs, 2 witnesses have already been examined, rest are examined, and next day the hearing is fixed to 23 not yet service.
23 no?
Service.
Oh, least after 23 no. Yes. 23 no, the result of it. Yes.
51.
I beg to submit my lord, that is one application to release interim bail because my mother was serious, my lord. The offense is 419, 420, 468, 471. Date of arrest is 29/11.
29?
29/11 to 2023. And
Huh.
the case has already been charged sheeted as 24/3/2024. Now
Okay.
custody more than 9 months.
What are the offenses?
Offenses 419, 420.
Acha, what have you done? Just see what are the allegations.
Allegation, my lord, that the informant itself be put in a vigilance case, he charge sheeted, my copy of the charge sheet I am submitting, my lord.
What are the allegations against you? Tell me.
That four
May I
LIC.
permitted, my lord. I am an BC, my lord, opposite party.
Yes.
I am opposite
what are
party,
these?
my lord. 12,91,000 has been taken by the accused petitioner, my lord. And the last occasion, our lordship said to pay some amount.
Yeah. Are you ready to pay?
My lord, if court order to pass, I'll pay.
Why should I pass the order?
What happening? They are, now he is the custody, my lord. Only single son. I have nobody. Aged mother of 85 years. I filed a petition to release on interim bail. ବାହାରିଲେ ସାନା ହଜୁର କୋର୍ଟ ଯୋଗାଡ଼ କରିକି ଆଣିକି ଦବ ନା ଇଣ୍ଟରି ମାସେ ଛାଡି ଦିଅନ୍ତୁ ତାପରେ ସେ ଆସିକିରି ଇଏ କରିବ ଏଇ ପ୍ରେଡିକାମେଣ୍ଟ ନହେଲେ ମାଇ ଲର୍ଡ ବିଫୋର ମାଇ ଲର୍ଡ ଭାଇ
If he will remain inside the jail, how will he arrange the money?
yes, my
Let
lord,
him
that
come out.
Last 2-3 occasions,
1 month.
he assured, my lord, to pay
I
today.
will record
Today,
that.
last occasion also he assured.
1 minute. I will record that he will make good the payments.
Yes.
I'll record his statement and I am granting bail.
That order may be there.
My daughter's marriage to be held, my lord. 10 lakhs never be
In a
in
bail
my
matter,
name.
I can't decide everything. It is not recovery proceeding. These are not
Your
recovery
lordship may
proceeding.
say to
I have
pay.
asked him to pay some money.
Yes, my lord. That
He
is-
doesn't have the money. He is in
Amount
custody.
will also, my lord, be observed. And I will pay.
I don't know. Petitioner is accused and so on, so on. Allegation against the petitioner in the FIR is so. Petitioner is in custody since 29/11/2023. Mr. Sunil Kumar Polai APS for opposite party number 2 and submits that the petitioner has cheated the informant to the tune of 12 lakhs.
2 lakh, 2 lakh.
Huh?
2 lakh, that are the
What is the amount, Mr. Polai?
12 lakh.
12,91,000. 12,91,000 some more. Yes, ma'am.
12,12.
12,91,000.
1,91,000. 1 lakh.
12 lakhs, 12 million.
12 lakhs 90,000. 12 lakhs.
Yes.
Wherever you say 12 lakhs, he says 1 lakh, you say 12 lakhs. Very good. 12 lakhs 91,122 rupees. 22 rupees. Let us consider the petitioner submits that although the petitioner is intending to refund the money to the informant, undisputed amount, refund the undisputed amount to the informant. However, since he is in custody, he could not arrange the finance. He further submits that his mother, who is 80-year-old, is terminally ill. So therefore, he sought an interim bail for a limited period. Regard being had to the fact that the petitioner is in custody since 29/11/2023, and the charge sheet has already been filed.
Yes, my
Charge sheet has already been filed on.
My lord, 24/3/2024.
I am inclined to enlarge petitioner on bail. Bail accordingly, the court in session shall release the petitioner on bail with the condition deemed fit and proper. The petitioner is undertaking to make good the part payment of the amount is subject within a period of 2 months after his release. With this observation, the petition is disposed of. After the release, within 2 months, you pay something. Okay.
My lord, condition bail.
I granted the bail.
बहुत चेष्टा करछि हजूर जमा करि पान अपन बगर अप्रस्त हे गेलु काना से तो
I gave a regular bail, no interim bail. Regular bail I have disposed of with the condition that within 2 months you will give. Otherwise, again, he will move application for cancellation. Okay. Yes.
On the dispute.
That condition may be put.
Yes, that condition I put it. Within 2 months, he will pay something.
Yes, oblate. Oblate.
Withdraw,
Oblate.
52 withdraw, 52. Yes.
54, 53.
My lord, item 53 on behalf of Mr. PK Paddy. PK Paddy's mother is died, so in this 2 weeks time requirement.
Oh, sir, urgent on the request. Yes.
54.
Yes. 54. Nobody is there. Case diary. Ask for case diary. Case diary. Case diary is there.
Yes, there.
Offense
Offense, my lord, 306, my lord.
306. Pass over. Okay. Hmm.
55.
Pass over.
Yes.
My lord, may I pray one thing, my lord? My lord, this is a matter of 302.
55.
55, my lord. In last occasion, your lordship was directed for obtain the
Case diary is not there.
statement. Case diary is not there because due to wrongly typographical
Case
mistake.
diary is not available yet. At least the matter. Yes.
6.
Maybe.
Yes.
Offense under section 302.
302. Yes. Case diary is there.
Yes, my lord.
Yes.
Posted is in 17/12/2022.
17.
12.
Hmm.
22, man.
22. Okay.
My lord. Charge sheet already sir, submitted.
What are the allegations?
On the allegation, my lord, they won all the deceased along with the present petitioner. Purchase some toddy, my lord, liquor, my lord, and consume some of the liquor, my lord. After that, my lord, after some time, the present petitioner went to the deceased house and asked the rest of the toddies. There is the alteration of words between the parties. My lord. All of a sudden, the deceased assaulted bite the petitioner, and subsequently the petitioner assaulted by means of the medha.
By means of a
Medha, that stick.
Okay. Yes.
And yes, my lord.
Yes.
My lord, it's a matter of 302, my lord. If your lordship will kind of have a glance to the postmortem report and also as well as the 161 statement of eyewitness wife of deceased, my lord, and another one 161 co-friend also, my lord, eyewitness.
Two eyewitness.
Yes, my lord.
One eyewitness reading.
My lord.
Yes.
Or Nama Purnima ji.
Relevant part. Don't read.
Yes, my lord, exactly, my lord.
Yes.
My lord, of this petitioner that
But
here
sudden.
yes, my lord. At best, my lord.
22 is there.
Yes, my
Witnesses
lord.
have been examined.
My lord, I'm saying, my lord, yes, my lord. Regarding that, my lord, till date, my lord, till the date of rejection order, my lord, 19/12/2023. Till date, out of 25 numbers, 6 witnesses have been examined and 7 witnesses have declined. So the 13 numbers witnesses already been examined, and the rest of witnesses may be examined within this last 7 months.
3 months. 3 months. 3 months. These witnesses, the eyewitnesses have already been examined?
Yes. No. Regarding that, I have no instruction, my lord. Already
examined.
That
When? The date you tell me.
That, my lord, August.
23.
23.
3. Right down. The petition is accused on so there are direct allegation against the petitioner regarding the assault by him to the deceased. There are 2 eyewitnesses to the occurrence. How many witnesses total?
Total witnesses, my lord, 25, my lord.
Out of total 25 witnesses.
13 number has already been.
Witnesses cited in the charge sheet. 13 witnesses have already been examined. Therefore, at this stage, I am not inclined to enlarge the petition on bail. However, petition can renew on the bail plea after 3 months if the material witnesses are not examined by then. And if such application is moved, the same shall be considered on the basis of the material available on record then. With this observation, petition is disposed. Yes.
2 months.
3 months, 3 months. 6 months I was thinking, I made it 3 months. Yes.
57.
57, my lord. Already evidence closed.
Close. Since the evidence before the trial court has already been closed, at this stage, I am not inclined to enlarge the petition on bail. Hence, disposed of. Yes, next.
58.
Lordship,
Same.
liberty may be granted to move after examination of the victim.
Right, and petitioner, counsel for the petitioner, Triparty, counsel for the petitioner submits that liberty may be granted to him to renew his bail plea after the
Examination of the victim.
after the examination of the
Victim.
victim. At this stage, he doesn't want to praise the same. Liberty is granted to the petitioner to renew his bail plea after the victim is examined. Yes.
Only one prayer mail. The victim is, they are not examining the victim matter. So I pray your
So
Lordship.
3 months, 3 months.
Yes.
3 months, huh? 3 months. Victim, if the victim cannot be examined for any reason whatsoever, the petitioner is at liberty to renew his bail plea after the expiry of 3 months.
Okay.
Yes. Hmm? Yes, 50.
59.
58.
But you don't seek adjournment there. That also I'll try. Your lawyer will take, not you. That's right. You are right. Nowadays that system is there.
59 million, 59 on behalf of Mr. Mahapatra, 1 week after.
Adjourned. At the request. Yes.
Obliged.
60.
60 may I please.
Yes, sir.
On the last occasion, Lordship has heard this case, my lord.
Lordship, in this case, I am appearing for the informant, your Lordship.
376, 506, 509.
Matter is settled.
Relationship is there due to some
Yes, yes, sir.
Yes, my lord. CD
As per my instruction,
major
your
girl,
Lordship.
my lord,
A major girl.
for 27 years.
What do you say?
As per my instruction, your Lordship, the informant is married, Lordship.
Married.
Married to
Elsewhere.
Yes,
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 elsewhere.
yes, ma'am.
And
Matter is settled
does he
outside.
have
the
any objection?
court. No, your Lordship.
He doesn't have no.
Your Lordship.
Also, and allegation against the petitioner so and so entered appearance on behalf of the opposite party number 2 and submits that the victim, the prosecutor has already married elsewhere and leading a happy marital life. Therefore, he doesn't want to. He doesn't have any objection if the petitioner is enlarged on bail, Regarding head to the nature of allegation, period of custody from
6/2/2024.
6/2/2024 and
Charge sheet already filed.
the nature of acquisition and the fact that the charge sheet has already been filed on
Charge sheet filed on 6/4/2024.
6/4/24. I am inclined to enlarge the petition on bail accordingly granted.
Obliged.
Yes.
Well,
My lord, CD has not come.
Mokalatnama taken on record.
এই 376 କେସ୍ ଗୁଡାକ ଏଗୁଡାକ ମାନେ ଟିକେ ଅଧିକା ପେଣ୍ଡିଂସ ହେଇଗଲା ବେଳକୁ ସେପଟେ ଭିକ୍ଟିମ ସାଇଡ୍ କମ୍ପ୍ରୋମାଇଜ ହେଇକି ଆକୁ ଟାଲି ଯାଉ ସେ ହଉ ମୁଁ ଆଜି ମୁଁ 2ଟା ନା 3ଟା ନୋଟ ପ୍ରେସ୍ କରିବି କଣ କରିବି
Yes.
Item 16, my lord, trial has already commenced. 2 of the witnesses have been examined. My lord, the next date is posted to 21st. My lord, I am praying.
Then you review bail plea there.
No, my lord, on 30th, my lord, I will produce the copies, my lord.
As a land counsel for the petition submits that the trial has already been commenced and material witnesses have already examined. He wants to place on record the evidence of those witnesses and leaves the matter. Yes. Next.
62, 63 is, my lord, arising out of same affair.
Same. 62 and 63 also.
Yes, ma'am.
My lord, 61, 62,
And 63.
Three.
All the 3 matters, material witnesses have already examined. Yes. 64.
64 million on behalf of Mr. Sahu next week.
Not next week, anyway, urgent on the
Urgent.
request. Surrender certificate have you filed? Filed in the court, taken on record, yes.
Sorry, I have no knowledge.
Urgent on request.
Obliged.
Yes.
5.
Last occasion, Lordship directed the petition counsel to file comprehensive affidavit.
Affidavit, na?
My lord.
13 cases and 3 cases.
13 numbers.
What are the offenses?
394 million.
3?
394.
390.
Knife and
Pass
one
out,
sim.
pass out, yes, pass out, yes.
66.
Permitted to place on behalf of the
Yes.
here on the alleged offences under section 302, 201, 34, 120.
CD is there?
Yes, ma'am.
Yes.
120 the IPC.
Yes.
And in the first case, there are three petitioners out of, and the petitioner number 1 is the father of the deceased. Petitioner number 2 is a lady, the PUC. Then petitioner number 3 is the villager. Another case is
The petitioner number 1 is the father of the deceased.
Father of the deceased.
Okay.
And the allegation in the FIR that the father has caused the death of the son.
Son.
Yes.
Yes.
Placing the statement of one Piru Marandi.
Hmm.
Now, placing the relevant person. ତେଣୁ ଆମର ସନ୍ଦେହ ହେଲା କି ତାଙ୍କୁ ତାଙ୍କ ପରିବାର ଲୋକ ମାରିକି କାହା କିଛି ନ କହି କେଉଁ ଆଡ଼େ ପଳାଇ ଯାଇଛନ୍ତି। ଶେଷରେ ମେଘରାୟ ଟୁଡୁର ମାଆକୁ ଖୋଜି ଆମେ ଗାଁ ମୁଣ୍ଡରେ କାନ୍ଦୁଥିବାର ଦେଖି ତାକୁ ପଚାରିବାରୁ ସେ କହିଲା କି ମୋ ପୁଅକୁ ଗତକାଲି ଦିନ 2ଟାରେ ତାର ବାପା ସାଲାଇ ପିଟିସନର ନମ୍ବର 1 ବାଉଁଶ ଠେଙ୍ଗାରେ ପିଟୁଥିଲା। ସେଠି ତାର ପିୟୁସି କାର୍ମୀ ପିଟିସନର ନମ୍ବର 2 ମାଣିକପୁରର ଚାନ୍ଦୁରାମ ଟୁଡୁ ପିଟିସନର ନମ୍ବର 3 and ତାର ବାପା ଲିଟା ଟୁଡୁ ମୋ ପୁଅକୁ ଧରିଥିଲେ। ସେମାନେ ସବୁ ମୋ ପୁଅକୁ
These two and 3 were holding and he was beating.
Yes.
That's what he
That
is.
is the allegation. Because that was the statement because Piru Marandi has heard from the mother of the deceased, the wife of the deceased. ସେମାନେ ମୋ ପୁଅକୁ ମାରି ଘରେ ଥିବା ଧାନ ଚାଉଳ ବଳଦ ଧରି ମାଣିକପୁର ପଳାଇ ଯାଇଛନ୍ତି।
Any eyewitness?
My lord,
No,
actually,
my lord.
eyewitness is the mother of the deceased and the
Her
wife of the
petitioner number one.
petitioner number 1. In her 161 statement, she has categorically stated all things. In
Her
164
statement has been
statement, my lord,
recorded.
She has been examined.
No,
She was not
section-
been examined.
Under section 164, her statement has been recorded. And in the 164 statement, she has stated that the deceased fell from the tree. And as a result of which,
So read out.
my lord, he was turned up in 164, she was turned up
and in
to
the
save her
postmortem
husband.
report,
But now 164 is there, 161 forget. Now 164 assumes
My lord,
important.
there is two opinion. In 161, one thing she has stated. In 164, she has
So
stated one.
which evidence?
My lord, let she be examined.
Oh, huh?
Let she be examined before the court.
He's right.
That
there,
is
miss.
because she
Hello.
saved
For
her.
the 3 months. You examine.
Yes,
Within 3
yes,
months. Right now.
there
Because
is custody since
I know.
October 2023, my lord.
23. That's what there is eyewitness. The mother of the deceased and wife of the
161 statement value of
see
the
161 statement and there is contradiction in 164 statement.
that was recorded in before the court construct.
That's right. But
Yes.
still she has to examine. I don't know. She may reiterate 161.
No, may not.
May not.
May not also read.
You never know.
That-
You
she
never
may
know.
read that
So,
section 166.
best is within 3 months this
Yes,
witness has to be examined. If you can't do it, he will renew the bill.
Yes.
And the postmortem report shows that the death is caused due to the injury caused to the head. That is the postmortem report. And had there
Beaten
been
up. Beaten up.
Head injury is there and wooden
No,
plank was
there-
seized.
because this one in the 161 statement, my lord, the mother stated that assault was made to the legs of the deceased.
I know there is a contradiction right on.
And your lordship may
Petitioners
consider
are
so far as petitioner number 2 and 3 is concerned. Petitioner number 1 is concerned, your lordship may
they were
direct that-
holding. They are
that-
holding the.
They are already in custody for about 1 year.
ବାପ ପୁଅ
voting.
ଝଗଡା ହେଇଛନ୍ତି
ଆଁ?
ବାପ ମାନେ ସେ ମଦ ଖାଇକି ଆସି ଝଗଡା କଲା ଝଗଡା ପରେ ଏମାନେ ଧରାଧରି କରୁଛନ୍ତି ତାପରେ ଧରାଧରି କଲା ଭିତରେ ସେ ବାଡେଇ ଦେଇଛି ବାପା ରାଗରେ ପିଟି ଦେଇଛି ପୁଅକୁ ସେଥିରେ ସେ
You are
ମରିଗଲା
appearing for whom?
କିନ୍ତୁ କେହି ଆଇ ୱିଟନେସ୍ କେହି ଦେଖି ନାହାନ୍ତି
You
ମରିବା
are appearing for whom?
Another accused.
ଆନନ୍ଦର ଆଗରେ ଲିଟା ବାଇଧର ଟୁଡୁ
Petitioner, father of
When
the
he-
three.
My lord,
No, you are appearing for Karmi to do.
ୟେସ୍
No, no, magnitude I am appearing.
Huh.
Petitioner number 2.
connected matter.
You are appearing.
Either two.
ବାଇଧର
Connected
ଲିଟା କନେକ୍ଟେଡ ମ୍ୟାଟର
Father of
Rita to do.
petitioner
What is the allegation against Lita?
ଲିଟା ବାଇଧର
Lita, Lita and
2, 3 and Lita. but they
All
started
3 of
saying
them, the ladies, huh?
ୟେସ୍
They
that-
were
No, not
holding.
ladies. They were holding only. That is the allegation.
That's right. They are ladies.
No, not ladies.
Huh?
One petitioner number 2 is only one lady.
My lord, all are assaulted. That is the statement of the eyewitnesses.
Well,
No,
And
all are
let she be examined, my lord.
3 months.
Because-
3 months. Right on.
Yes.
super others are-
The petitioners are accused in FIR number so and so.
ଛୁଟି ପରେ
It is
ରଖିଥିଲେ
alleged. No. It is alleged that the petitioner number one was the father of the deceased had beaten up the deceased and the petitioner number 2 and 3 along with one Lita were holding the hands of the deceased, the deceased. The mother of the deceased, who is the wife of petitioner number 1, is the eyewitness to the occurrence. In the 161 statement, she has made the allegation. She had stated that these petitioner number 1 has assaulted the deceased. At that point in time, the petitioner number 2 and 3 and Lita were holding the deceased. However, in 164 statement, he had wriggled out of her earlier statement and given a different version. Mr. Mishra and counsel for the state submits that in view of the fact that the sole eyewitness to the occurrence has two versions. One recorded by the police under section 161 CRPC and subsequently the statement recorded under 164 CRPC. It would be apt that the said witnesses, the bail plea of the petitioners shall be considered after the examination of the said eyewitness. I am in agreement with the counsel for the state, and accordingly the trial court is directed to do well to see that the sole eyewitness, sole eyewitness to the occurrence, who is the wife of the petitioner number 1 and the mother of the deceased, shall be examined, giving preference over all other witnesses. Thereafter, the petitioner may renew the bail plea. Since only one witness is to be examined preferentially, and therefore the petitioner may renew the bail plea after the expiry of 3 months in the event.
2 months.
Okay, 2 months in the event the said witness would not be examined for any reason whatsoever. With this liberty, the petitions are.
The copy may be.
Number 1. Consider other. So
There are two versions.
Since October 20.
I understand 2 versions, 2 months. Therefore, I am giving 2 months. It is made clear that the petitioners, on behalf of the petitioner, no adjournment shall be sought before the trial. 2 months.
Though the charge sheet was submitted in the month of February, the trial has not been started till now.
3 months I have given. 3 months, 2 months. 2 months I have given. If they don't do it, repeat it.
Okay.
Then you are entitled to be.
Connected matter also, sir.
Connected matter also, both the matters.
Because on the strength of individual, she was arrested just before 3 months.
Whatever on merits will see, otherwise they are entitled to bail because of the contradiction only.
Contradiction only.
Happened. So therefore, yes. Yes, 67. 67.
And for the informant matter.
Yes, sir.
And for informant matter.
Who is for petitioner? None.
The last occasion was directed to deposit to file the deposition copy of the PW5, who is victim.
Password. Yes.
67, Your Lordship. May I please, Your
Yes,
Lordship?
madam. 67. Okay. Yes. Yes, madam.
Your Lordship, interim protection may be granted to the petitioner, Your Lordship, for the
Interim protection for what?
Your Lordship.
Because you could not file what you are supposed to file. Therefore.
No, Your Lordship. Your Lordship has asked for the instruction of the victim, Your Lordship. Victim's family.
My lord, is the offense under 3762, 373, and 365 IPC and section 6 of POCSO. The victim is a minor.
He is in custody since.
The last time you directed him, the counsel sought him whether he
4/5/2021, Your Lordship.
Yes.
But that is
Yes, Your Lordship. You had sought
Any
for the
instruction to that effect?
Petition accept କରୁଛି କିନ୍ତୁ family member ମାନେ ରାଜି ହଉନାହାନ୍ତି.
Yes, Your Lordship.
Family of the petitioner.
Family of the petitioner. Yes, Your Lordship.
They are not agreeing.
No.
They are little reluctant, Your Lordship, but the petitioner is ready to get married.
No, interim bail, on what ground interim bail? You have to give me the ground.
The petitioner
You move
wants
an
to
application for interim bail.
Please,
You move an application
Your
for interim bail, I'll consider it.
The family law राजी होना
Let the counsel for the petitioner seeks 1 week time to file 1 week time, 1 week adjournment on the ground that she intend to move an application for interim bail. Least matter. Let her move an application for interim.
My lord, simultaneously also file the deposition copy
And
of the
she
victim.
is no, let her not file. I'll decide.
File?
Yes. 68.
Please, Your Lordship.
Yes,
Well,
68.
offense under section 354D, 506, 34 IPC.
Yes.
Read with section 12 POCSO Act. Petitioner custody
You are in
since
custody since
3/2/2024. 3/2/2024.
3/2/24.
My lord.
Yes.
Charge sheet submitted 31/3/2024.
Charge sheet filed.
My lord.
Yes, 31.
Charge sheet submitted after rejection order.
31.
3/2024.
3/20/24.
My lord.
Okay. In charge sheet, what are the offenses?
354D, 506, 12 POSCO.
354 only.
354D.
There is no penetrative.
No, no.
So that can't be. There is no penetrative. He is in custody. Right now. Petitioner is accused on FIR notes also. Allegation against the petitioner also. The medical exam, the charge sheet after investigation, charge sheet has been filed on 31/3/2024. The medical evidence and the charge sheet reveals that the petitioner reveals that there is no penetrative sexual assault committed by the petitioner. Therefore, the offences under section 354 capital D read with section 12 of POCSO has been alleged against the petitioner. The petitioner is in custody since 3/2/2024. What is his age? And who he is a 25-year-old. He is 25 years of age. The victim is
15.
Victim alleged to be what is this?
The victim on the date of the
Therefore,
164
implied
record is
on bail accordingly condition and with additional conditions. Yes, next.
Obligation.
74.
69.
74. Yes,
May
69.
I please?
Yes, sir.
Well, the petitioner is in custody since 11th March 2024.
11 March.
Sorry, 13th March.
13/4/24.
13/3.
3/24.
Yes, madam.
Okay.
Madam, I have annexed the FIR under Annexure 1, page 8.
What are the allegation?
Allegation in the victim, my lord, on the December 30 of 2023, lodged an FIR which is registered under section 294, 323, 354, 506. What happened, my lord?
Charge sheet filed?
Yes, ma'am.
What happened?
What are the offenses?
Charge sheet
On the after
372 and 313, 6 POSCO, 66, 67 ITI.
that I am submitting.
Yes.
But the FIR, my lord, page 10 kind of plans, my lord.
Forget about FIR. Now, charge sheet has been
After
filed.
3 months, she made allegation in the 164 statement. After 3 months, 164 statement was recorded. She stated that in the
Read the 164.
since 2018 they were in love relation.
Read 164.
My lord. 31%.
What is the age of the girl?
20 years, my
20
lord.
years.
20 years, 9 months.
20 years.
20 years.
Okay. This boy is
24.
24 years. Yes.
Though minor allegation is that 66, 67 ITI,
Nice.
some photographs were seized.
Asked the accused persons to accompany him to police station. They did not go. So there was a dispute. It is alleged that for that reason they killed him.
For the present petitioner, though is the father of the accused person, in the 164 statement of the grandfather of the deceased, who is the eyewitness, he says, Surendra Bhuya, Mongala ku mada mari nathila, କିନ୍ତୁ ସେ ନିଜ ପୁଅ ମାନଙ୍କୁ ମଙ୍ଗଳାକୁ ମାର ବୋଲି କହୁଛନ୍ତି। That could be interesting.
And how many accused?
My lord, 3 accused persons are there. One is the present petition, who is the father. Other 2 persons bail petition is pending. And my lord, the leading to discovery that Poturi was seized from the son of the present petitioner. And knife also seized from another accused persons. What happened, my lord? The same. 161, they are eyewitnesses, they have stated in 161 statement. But in the 164 statement, they have not stated. So let they examine before the court below, my lord, because there is contradiction between
the same
161 and 164.
64 statement, the grandfather.
What is the stage of the trial?
I am not yet.
Trial stage, my lord.
Charge has been framed.
Not yet begun. The grandfather said, this fellow, of the deceased, he was not asserting, he was instigating. According to anything, he was instigating.
No, more than 5 eyewitnesses are there. 5, 6 eyewitnesses are there. All are stated in 160.
What is the role of Surendra Bhuya? He is the father of the main accused, principal accused, those who have assaulted.
Yes, ma'am.
And he has only instigated them.
I'm
That's
reading
the allegation.
161 statement. 161 statement I am reading, my lord. One of the eyewitnesses I am reading.
161 police rights. 164 belongs to the court records. If you ask people, kindly see 164.
The 164 of the one of the eyewitnesses.
My lord, eyewitnesses.
Read out
164 statement, they have not stated anything. But in the 161, they have stated.
You have recorded statement. How many witnesses you have recorded? 164?
My lord, 164. 3, 4 eyewitnesses, 164.
All the eyewitnesses you have recorded?
No, all the eyewitnesses are not. Only there is more than 5, 6 eyewitnesses.
Read out 164, let us see.
I am reading first 161, then 160. One Lambodhar Pradhan.
I have no dispute that.
Aji Sokale Pakapaki Opat
02.
My lord.
Pass over. Okay, next.
75.
May I please?
Yes.
My lord, magistrate table offense, my lord. The co-accused persons were released on bail by the learned court below.
Custody?
My lord, the petitioner is inside custody since, my lord, his date of arrest, that is, my lord, 6/2/2024.
6/2/24.
Okay.
What
This is the order of the co-accused.
What are the allegations?
Allegation
They are demanded money and taken away money purse containing 4,000 rupees. Mobile
antecedent?
Say antecedent ଅଛି ବୋଲି ଆଜ୍ଞା
4
reject
numbers of similar nature points.
379 କେସ୍ ଗୋଟେ 2001 ମସିହାରେ ତାପରେ ଲେଖା ହେଇଛି ରିଜେକ୍ସନ ଅର୍ଡର ଲେଖା ହେଇଛି 19 ବର୍ଷର
Gold chain and mobile phone also seized from the other co-accused.
19 ବର୍ଷର ପିଲାଟା
the present petitioner.
19 ବର୍ଷର ପିଲାଟା
19 ବର୍ଷରେ how many cases you have?
ଚାରିଟା
I will allow, but subject to verification up for the antecedent.
ନା antecedent ଲେଖା ହେଇଛି ଆଜ୍ଞା page 10 page 10 of the order.
All other
yes these are order.
311 is there.
Hello?
311.
394.
379, 311. What are the offenses?
394, my.
394, my.
See, the problem is you don't file anything except the rejection order. Where file? What is the charge? FIR? Nothing is there. How will I get it? Anything? I'm trying to find out. Charge sheet is filed.
Yes.
Everything in this court is in oral submission. No, nothing on record.
That is reflected in the rejection bail order also.
Page
10. I don't know how you people are filing bail application without filing FIR, without filing charge sheet, without anything. Except rejection order, nothing.
Page 10, my lord, first para. Page 10.
How many accused are there?
3 accused persons.
File the charge sheet copy. Let me understand how many witnesses, how many. At least I should know how many accused persons are there. You have shown me this. How many witnesses? How many accused have already been enlarged on bail?
2, my lord.
2. That
Total 3 persons, my lord. Total
Ashish
3.
Khora.
Ashish Khora and another is there.
Another is?
His name is reflected in the first.
Raja.
Yes.
And how many other?
Total 3 witnesses.
Where from I'll get it? At least file the copy of FIR.
FIR is unknown, my lord. FIR ରେ ଦେଖାଯାଉନି କିଛି ସେଇ ଯୋଗୁରୁ ତମେ ଆଣିନ କିଛି
Charge sheet is filed, huh?
ଚାର୍ଜ ସିଟ୍ ଇଜ ଫାଇଲ୍ଡ
You file the charge sheet, copy of charge sheet. Let counsel for the petitioner seeks adjournment to file the copy of place the copy of charge sheet on record. Release the matter after 1 week. You should next topic.
Yes.
File the charge sheet at least.
Yes.
Yes.
76. Sir, item 76, it was earlier disposed of by Honorable Justice A.K. Mahapatra.
What happened?
Earlier disposed of by Honorable Justice A.K. Mahapatra.
What have you filed here?
I filed this bail application. It was the successive bail application, Your Lordship.
Oh, this is.
I have also given
successive
certificate.
bail application. The earlier bail application has been disposed of by the coordinate bench of this court. Please the matter before the coordinate bench, which has decided the earlier bail application of the petitioner, subject to the permission of the Honorable Chief Justice. Yes.
77.
Yes.
376-1, 323-506.
Custody.
My lord, the petitioner is in custody since 29/3/2024. And charge sheet,
Yes.
no, my lord.
76.
My lord, 8/3/2024, and the charge sheet was filed on 29/3/2024.
Yes. Yes. Charge sheet has already been filed on.
29/3/2024.
Yes.
My lord,
164. Read 164.
my lord, the complainant is major, my lord, 27 years. The petitioner is also around 26-27. They are having.
Show me the 164. Read
Yes,
164.
that is there. And my lord, my learned friend is also appearing for the year. And
What do you say?
and they were in a relationship. Some dispute arose thereafter this case.
What do you say?
This is the annexed to the bail application. The informant as well as the petitioners are co-villagers, taking advantage some money due to intimacy known to each other. The accused has taken some money from the informant and called to his residence on a particular day. Thereafter took the photograph to refund the money. He has asked to give some food and
Not food, cold drinks. On cold drinks, is
And
given
then,
some tablet and then
assaulted.
in the
Yes.
mistake, he has already taken 3 lakhs. Your lordship can see the FIR.
This is the, are you using this FIR for recovery or something else?
If the settlement will be made, both the life will be settled.
He's interested in his money, not for anything else.
ସେ ମୁଁ କହିଲି ପରା କଣ dispute ହେଇଛି ବୋଲି କେସଟା ହେଇଛି.
So shall I enlarge you on interim bail? You pay the money. You have to pay the money. You have taken.
ସେ ତାଙ୍କ dispute ଟା
taken the
settle
money
କରିଦେଇକି
and-
ଆସିବେ ତ ହଜୁର ମୋତେ interim bail ଦେଇ ଦିଅନ୍ତୁ 2 ମାସ. ସେ ତାଙ୍କ
20 days କଣ 2 ମାସ ରେ ଆପଣ ସେ ଇଏ କରିବେ.
And the very fact that he has taken 3 lakh rupees from you, and this FIR is the manufactured one, only to extract the money. See, looks like.
The FIR. Cold drink, giving the cold drink.
she is working as a staff nurse and the
164. Read 164. Do you have or not?
Yes.
Read it. Relevant part.
ହିମାଂଶୁ ମୋ ବୋଉ ଠାରୁ ମୋ ଫୋନ ନମ୍ବର ନେଇ ମୋତେ ଫୋନ କରି ଦେଖାହେବା କହିଲା। ସେ ମୋ ସାଙ୍ଗ ହୋଇଥିବାରୁ ତାର ବାରମ୍ବାର ଅନୁରୋଧ ପାଇଁ ମୁଁ ତା କଥାରେ ରାଜି ହୋଇ ତାକୁ ଦେଖା କରିବା ପାଇଁ ରାଜି ହେଲି। ସେ ମୋତେ ବରମୁଣ୍ଡା ଗ୍ରୀନିସ୍ କଲରକୁ ଡାକିଲା ଓ ସେଠାରେ ଆମେ ଦେଖା ହେଲୁ। ପରେ ମୁଁ ମୋର ହଷ୍ଟେଲକୁ ପଳେଇ ଯାଇଥିଲି। ଏହାର କିଛି ଦିନ ପରେ ହିମାଂଶୁ ପୁଣି ମୋତେ ଦେଖା ହେବା ପାଇଁ କହିଲା। ମୋତେ କଳିଙ୍ଗନଗରକୁ ନେଇକରି ଗଲା। ସେଇଟା ତାର ଘର କହି ଘରକୁ ନେଲା। ଆମେ ଦୁଇ ବନ୍ଧୁ ସେଠାରେ ବସି କିଛି ସମୟ କଥାବାର୍ତ୍ତା ହେବା ସହିତ 2 ଜଣ ଖାଇଲୁ, ଥଣ୍ଡା ବି ପିଇଲୁ। ମାତ୍ର ସେ ମୋର ଥଣ୍ଡାରେ କ'ଣ ମିଶାଇଥିଲା ମୁଁ ଜାଣି ନାହିଁ। ହେଲେ ସେଇ ଥଣ୍ଡା ପିଇବା ପରେ ମୁଁ ଅଚେତ ହୋଇଗଲି। ଏହାର ସୁଯୋଗ ନେଇ ସେ ମୋ ସହିତ ସାଚ୍ ମୋର ହୋସ୍ ଆସିବାରୁ ମୁଁ ନିଜକୁ ଅସଂଯତ ଅବସ୍ଥାରେ ଦେଖି ତାକୁ ଏ ବିଷୟରେ ପଚାରିବାରୁ ସେ ମୋତେ କହିଲା କି ସେ ମୋର ସାଚ୍ ଫଟୋ ରଖିଛି, ଯଦି କାହାକୁ ଏ ବିଷୟରେ କହିବି ସେ ମୋର ଏ ଫଟୋ ସବୁ ଭାଇରାଲ କରାଇଦେବ।
List next week. You seek instruction. How much you will pay? Pay something and regular pay. Pay something next week. Next week. Tell him to pay something. She is interested in getting the money. Looks like. Have you investigated what are the
investigation ରେ କିଛି ଆସିନି ଆଜ୍ଞା. ଚାର୍ଜ sheet ରେ କିଛି
medical
ଆସିନି.
evidence?
Medical evidence is nil, madam.
That was not that next day. That was after 5-6 days. But
Medical evidence is nil, and And in the charge sheet in the investigation, there is no material with regard to taking and giving of any money from either side. That is in the charge sheet also.
Next week, just see, ask if he has taken money, he has to pay. Otherwise, I'll grant pay. Okay. Next.
78.
Wait, please, Your Lordship. There are two cases.
Yes.
There are prisoner petitions. If you are,
72 cases. Okay.
if your Lordship allows the prisoner petition, I may proceed. If your Lordship allows the prisoner petitions, I may proceed.
Yes, yes, of course.
My lord, allegation under section
Both the
354.
petitions are prisoner's petition. Huh?
My lord,
Yes, yes. Yes.
allegation, my lord, under 454, 480. Allegation is that they broke into the house, theft of 13 lakhs rupees and a smartwatch. And the petitioner was arrested on 18/1/2024. 18/1/2024.
24, okay.
And 75,000 has been recovered from him. He has 8 criminal antecedents prior to 2016.
And what about the second bail application?
Second bail application, my lord, he has no criminal antecedents. And he was also
He is one of the accomplices with
accomplice, my lord.
Both were there.
Huh?
Both were in a
There were 3 to 4 persons.
Hyundai vehicle has been recovered with 2 lakhs something. From him, 1,40,000 here from the 75,000.
But see, he is in custody.
They are out of state, lordship.
January 24, both of them. Huh?
Haryana and one is Haryana, one is Gujarat.
Gujarat, Haryana.
And they were arrested from Gujarat and Haryana.
Gujarat, Haryana.
On any
what is the
stringent
stage of trial?
That part I don't.
Huh?
That part is not.
Charge sheet has been filed.
Instruction regarding the status of the trial in the present case. Please the matter after 2 years. Let us see. Yes, next.
Yeah, Your Honor, item number 79, my lord.
Yes.
In this case, in total 140 kg of ganja has been seized from an auto. The present petitioner are the passenger in that auto. The driver of that said auto has absconded, and for which the present petitioner have been implicated in this case under section 20B2C. My lord, they are in custody since 2nd November 2023, and in the meanwhile, the police has also submitted charge sheet in this case, and trial has also commenced, my lord. My lord, even though the police has submitted a charge sheet in this case, surprisingly, no document has been submitted along with the charge.
When the charge sheet was filed?
Lordship, charge sheet was filed on 30th April 2024. Rejection is 18/4/2024.
No, charge sheet, then you go to the trial court.
Yes.
Charge sheet is filed subsequently.
Yes.
My lord, kindly hear me out for a moment. My lord, even though the police has already submitted charge sheet in this case, but surprisingly, they have not submitted a single piece of document to prove the compliance of mandatory provision of NDPS Act, my lord. My lord, they have not submitted a single document showing that they have complied section 42, or that they have complied section 50, subsection 6, or that they have complied section 52A2 in the charge sheet, my lord. Furthermore,
chemical examination report, please.
My lord, chemical examination received, my lord.
Then you have a good case for bail before trial court.
Yes,
trial court will not give bail under section.
You don't be apprehensive about that. Right now.
Because
Petitioner is agreed by the order dated 18/4/2024, whereby his bail plea has been rejected. There is a recovery of 140 kg, 750 grams of contraband ganja. The charge sheet has been filed in the present case on 30th of April 2024. Since the charge sheet is filed subsequent to the rejection of the bail application, in the changing circumstances, petitioner shall approach the court of first instance by renewing his bail plea. With this observation, if such bail plea is moved by the petitioner before the court below, the same shall be considered on the basis of the available record, forms part of the charge sheet within 15 days from the date of moving the application. With this observation, the petition is disposed of. Next. 79. Yes.
79 Golapura.
79. Okay. 80.
80 man are permitted to withdraw, already acquitted.
Okay. Mr. Arjit Mishra and counsel for the petition seeks to withdraw the petition as the petitioner has already been acquitted. Yes.
81.
Yes. 81. Case diary is there? Do you have the case diary or not? Four two one eight. Case diary in the present case is not yet been made available to the council for the state, hence adjourn the matter. Yes. 82.
May I please, your lordship?
Yes.
But this is a peculiar case, my lord. My lord, occurrence is in the year 2010, my lord.
10.
That is 24/3/2010, my lord. FIR lodged on 6/4/2024, my lord, after 14 years, my lord.
14 years?
14 years, my lord.
You are in custody?
Custody, my lord, I am in custody 6/4/2024, my lord.
So, Chari?
2024, my lord.
Yes.
Charge sheet has been submitted on 2/6/2024, my lord.
Exactly. So
Now victim age is 27, my lord.
Victim.
2010, my lord.
Show me the charge sheet.
Charge sheet, my lord.
Right. Oh. See, these are the incident pertains to 2010.
Yes.
And FIR is registered in 2024. He is taken into custody.
Only gradually, my lord.
Right on. Right. Petitioner is accused in so and so. Allegation against the petitioner is so. The petitioner is in custody since 6/4/2024. The statement recorded 164.
Yes, 161, 169 is there.
The see the age of the girl. The it appears the allegation pertains to the year
Now is 27.
2010, and the FIR is registered in the year 2024. Yes, the statement of the victim under 164 CRPC was has been recorded. What is this?
Now 27.
Recorded at this at the time.
Is it about 21, Lord?
Statement.
27.
Her statement. She is 27 years of age.
In narrating about the 10 years back incident.
She has stated. She in her statement has narrated the incident pertaining to the year 2010. 2002. Regarding head to the fact that the petitioner is in custody since 6/4/2024, and the FIR has been registered after more than 14 years for the date of incident. I am inclined to enlarge the petitioner on bail accordingly. Bail granted. Yes, next. 83. Yes.
May I please, your lordship? On last occasion, notice was issued to the informant.
Yes.
Direction is given to the.
Not sufficient. Service not sufficient. Press steps to be taken to serve opposite party number 2.
Miller, also direction is given to the state council to
And
attend the 164.
Council for the state is also directed to serve the notice of opposite party number 2 through the IO of the case. Through IO. English 84. Yes. POCSO. Yes. Next. 65. Yes, sir.
Case of 307.
307.
My lord.
Custody.
Custody has been submitted. Custody since March 2024.
Date.
14/3/2024.
14/3/24.
14/3.
Okay. Charge sheet filed.
Charge sheet has been
30th
filed.
April 2023. 30th April 2024. 23.
Long-standing dispute between the parties. It is alleged that on the date of occurrence, around 8 persons have been named in the affair. I think
Charge sheet filed against how many?
12.
12 people. Huh?
I am for the informant, your lordship.
Two
persons named the charge sheet.
That is Dhanesh for Barik and?
He is the principal accused, is the accused
Yes,
number 1.
let me comment.
Yes,
my lord and friend is correct. I am the principal accused. Out of the 2 persons charge sheeted, that other accused has been released on bail. It is alleged that petitioner has assaulted injuries on the hands and leg. And he has been
What is the-
discharged since long, and after being discharged, he has
To
also been
understand
examined.
that 302 and either 307 is there.
No, no one.
Is there, I am.
302, he has been exonerated, not
If
arrested.
you also permit me, then I'll show the photographs of the
Yeah.
injured person.
Photograph for the file.
Yes.
Actually, that is found in involved in the
My lord,
High Court
my
case
lord,
number
my lord
111,
says he is having
29
two
for
antecedents.
24
Two
under
antecedents. One
section
is
2
302 has
antecedents.
been exonerated.
not
and-
exonerated, Lordship. That is 22.
22.
That is Noikodi PS case number
My lord,
111.
may adjourn this
dated
case. I will ask them to
29
file an affidavit.
22.
Mr. Dhar, Learned Counsel for the petitioner seeks an adjournment
And
to
307
place on record the antecedent of the petitioner, lease the matter after.
Initially, 302
Let us-
case is there.
he will file it, yes. 86, yes. Pass over, yes, pass over. 87.
May I please?
Hmm.
My lord, 302, 323, 325, 34. Petitioner is not named in the affair. Neither he has been named
That-
by any of the
CD is
witnesses.
there, CD is there with you?
No, Lordship.
Is there or not?
No,
No, no, ask me.
CD,
today,
call for CD.
today it was asked, yes.
And the CD was already called for.
Yes, yes.
Yes,
The-
it is called for today.
Learned
You
Counsel
are
for the
supposed
state
to give
submits that
today.
he has not received the CD of the case and the CD of the case pursuant to direction dated 6/5/2024, release the matter after 2 weeks. Yes, next.
88, my lord, on the last occasion, on 6/5/2024, CD and 164 statement was called for.
Yes, yes.
And also notice was issued.
Yes. Notice, sir.
Notice status ସେମାନେ କହିବେ 164 ଟା ମୋ ପାଖରେ ଅଛି.
164 is there, so what the notice is concerned, that certainly not obtained.
Yes. CD is not there.
Yes, there is there, madam. So 164 and the medical.
Notice was issued on the last occasion. Whether notice has been sufficient because 373 is there.
Hey, notice the see. Notice.
Notice.
Order ହେଇଥିଲା 6/5/24 ରେ.
Sir, which?
ତମ ପାଖରେ ନାହିଁ କି instruction? ହେଇଯିବ ନା? Substitute ହେଇଯିବ ନା?
No, no. Notice କଥା ନାହିଁ.
ବୁଝିପାରିଲ ନାହିଁ?
ମାନେ ସର୍ଭ ହେଇନି.
Solve ହେଇନି? ଆଚ୍ଛା କୋଉ
Notice on the opposite party number 2, the victim. Opposite party number 2 victim could not be served. The state council is directed to serve the opposite party number 2 through the IO of the case, release the matter.
particular date may be fixed so that
Date will be fixed. And
if
free copy.
if she wish she can appear.
Free copy through IO, sir.
My lord.
Okay. Next.
Obliged.
Yes.
Listed on 376 AB 506/294 and section 4 and 6 of the POCSO Act. And accused in custody 4th March 2024, my lord.
4th March
2024. In the meantime, charge sheet has been filed.
That's it when?
That is 4th May 2024.
In 24.
My lord.
Okay.
4th
Yes.
24, my lord.
And there, the fact of this, there is previous enmity between both the families, my lord. There are civil dispute between both the families in which we have filed FIR against the present informants father. Sorry, informants even, which is at present 15, my lord. In which we have, I have annexed, my lord. At present 15, our.
Who is opposite party number 2? Who is anybody appearing? See, you renew your bail, please. Go to the trial court. The petitioner is agreed by the order dated 16/3/2024, whereby his bail plea has been rejected. Firstly, the petitioner is accused in FIR. Bail plea is rejected. Then consequently, the petitioner submits that on 4/5/2024, charge sheet has been filed in the present case. He is in custody since 4/3/2024. Regarding head to the fact that the charge sheet has been filed subsequent to the rejection of the bail application, the petitioner should renew his bail plea before the court of first instance. If such bail application is moved, the same shall be considered within 15 days on the basis of the materials form part of the charge sheet. With this observation, petition is disposed of. Next.
90.
Yes.
May I please your lordship? Your lordship,
Yes.
this is a case under section 394 of IPC, and the allegation is that the present petitioner, along with one Sangram Patnaik and a unknown person, abused the informant and demanded 20,000 under threat to kill, and accordingly, the brother of the informant transferred the amount instantly through a QR code. This is the whole allegation here. And the case has been registered
You are in custody?
since 8
Series of cases, madam. 8 numbers of criminal antecedent is there.
You have antecedent, what to do?
Your lordship, the case has been charge sheeted, and the other two.
But how many cases you have against you?
Your lordship, 8 cases.
Oh, that's right. That's the problem.
Okay. Lot of the same material.
Oh, whatever.
The mother is so
Whatever. Right, in view of the 8 number of antecedent against the petitioner, the trial court has rejected the bail plea. The charge sheet has already been filed in the present case. How many witnesses are there?
Madam?
How many witnesses are there?
Witnesses, ma'am. Witnesses, my lord, that investigation is, my lord, in this case, my lord. Update CD is not there, my lord.
Call for CD.
Your lordship, the other two
I am calling for CD. Let us see. Yes.
Sir, other two persons has already been released on bail by the order of the honorable record.
That's right, but you have 8 antecedent against you. Let us see the case diary. What are the allegations? Okay.
Your Honor, the bail rejection order itself reveals that there is.
You want a rejection right now?
No, Your
Or will you wait for the? Will you wait for the diary to come? Case diary to come?
Your
Some
lordship,
part of the investigation is there.
trying to-
Update CD is required, madam. Update CD is required, madam.
Update CD should come, then I'll consider. Okay. Yes. 91. Yes. 91. Offense?
My lord, charge sheet submitted, my lord, in this case, 363, 368, 376 DA, and 376 2N, my lord.
Pass it over, huh? Pass it over. Let us see.
All right.
Next. 92. 92.
May I please, your lordships?
Yes, sir.
Here, my lord, alleged offence is 20B to C of NDPS Act.
Yes. Custody?
Custody since 14 to 2024. Case date of occurrence is, your lordships, 11/4/2013.
What is the recovery?
Recovery, my lord, it is alleged that it is recovered from the house of Benundhara Sahu, 128 kg, 200 grams of ganja. 3 persons, my lord, they have kept the ganja inside the house of Benundhara Sahu.
Benundhara Sahu.
2 persons have been released on bail, on anticipatory bail, like the present petitioner. There also the present petitioner was the petitioner, but his bail application was rejected and the 2 persons have been granted anticipatory.
My lord, item 91. My lord, item 91, I am present in BC. Item 91.
It was passed over. It was passed over.
Passed over,
Please.
passed over. Yes.
My lord.
Passed over, yes.
My lord, this is the bail, my lord.
Just, can you check it up? Whether the
as per
accused, those who have been enlarged on anticipatory bail,
my lord, as per
their role and this role of this man.
my lord, that as per the rejection order, my lord, that 128 kg, 200 grams of ganja recovered from the bedroom of the accused, my lord, petitioner, my lord.
Yes, 10 your lordship, may kindly.
Oh, this anticipatory bail was granted in 2013.
My lord.
You were in custody in 2024.
24, my lord, what is the charge sheet was submitted in the year 2020?
Because you were absconding.
No, we are not absconding. Because charge sheet was submitted in the year 2023.
Hey, can you just check it up? What is the role of these people?
My lord, let it take up some other side.
Yes, I'll just Land Council for the petitioner, Mr. Mahapatra, Land Council for the petitioner submit that 3 of the accused persons, co-accused persons, have already been.
No, my lord, two out of 3. 2 have been granted. 3 petitioners or 2 have been granted at
2 of the co-accused persons have already been enlarged on anticipatory bail by this court by order dated 22/11/2020 2013. Then comes for the state to seek instruction regarding the same and to ascertain whether the role of the present petitioner is different from the role assigned to the co-accused person, those who have already been enlarged on bail.
You will also posted it to next week. Or
Next week.
date maybe.
You give that order, please, to him.
Yes, I will get it. You please.
Yes.
May I please, Your Lordship?
Your order it is late. Could copy, please.
Next week date maybe.
Date will be given. Definitely.
May I
19?
please, Your Lordship, ma'am?
Yes.
The offense under section 20B of NDPS Act, only 10 kgs of ganja was seized, my lord.
10
Lordship.
Yes.
And
Custody since
since 12 to 2024.
12
to
to
2024.
23.
24.
24. Granted, subject to verification of NDPS.
Obliged.
Granted. 10 kilo. Is custody in 12 to 2024. Subject to verification of the NDPS. Yes.
24.
Please, Your Lordship.
Yes.
Offense under section 302 of IPC. Custody since 1 November 2023, my lord.
302.
My
Yes.
lord.
Diary is there?
Yes, there is there, my lord.
Yes, sir. Tell me.
Charge sheet has been submitted on 26 February 2024.
Custody form?
Custody from 1 November 2023.
1 November 23. Okay.
My lord.
Yes.
And the allegation is that the informant is the brother of the deceased, my lord. He got information from Gramarakhi that his sister is lying dead in front of the lying dead, and a weapon of offense is also lying near the informant, near the deceased, my lord. And there are no eyewitnesses to the occurrence, and only the case against the petitioner is circumstantial, my lord. They both were respectively married in their respective lives. However, 1 year prior to the occurrence, my lord, they were living together. Now that is the circumstance against the petitioner.
Who was living together? This is accused and
accused and deceased, my lord.
This is
Accused
a
and
lady.
Deceased is a lady, my lord. That is the circumstance against the accused, that he was living there and there were no eyewitnesses.
They live in relationship.
My lord.
No, my lord, that this is my lord, is a married lady, my lord. And the petitioner.
Married whom? Married somewhere else.
Married to Kartika Munda, one Kartika Munda. And that petitioner is concerned, my lord, Dukkulu Munda is also a married person and having one son, 4 years. And both accused and deceased developed extramarital affairs since after 2021. When their family members and villagers came to know about the affair, the accused and the deceased eloped and lived as husband and wife. And thereafter, during this period, Jyoti Munda did not allow the accused to visit his home for which dispute took place. The Aadhaar card of +2 certificate accused Dukkulu Munda was kept by the deceased Jyoti Munda. Whenever the accused asked for the documents of correction, the deceased Jyoti Munda did not listen and always avoided
Jyoti
him.
Munda is the wife of Dukkulu Munda.
Wife of my own Kartika Munda. Thereafter, there are yellow and he. And that there are the dispute among both the husband and wife. The petitioner and the Jyoti Munda. After dinner to the late evening, on the date of October 29/10/23, accused Dukkulu Munda, petitioner, asked for to give his Aadhaar card and certificate. For the deceased Jyoti Munda, again denied, for which out of the anger, the Dukkulu Munda, I know that petitioner assaulted the deceased by an axe, brutally with an intention to kill her, as a result which the deceased severe bleeding injury on her person and died. And that cause of death, my lord, is due to external injury, internal findings are antemortem, homicidal in nature, madam, and that 1/6 of
no.
That one was Nasanti Marana is there, one Bochan Samba, extrajudicial confession is there, and that confessional statement of the accused is there, and that weapon of offense has been sealed, and the police report also revealed.
No eyewitness, my lord.
Extrajudicial confession, recovery 27.
No recovery of the
recovery.
Weapon of offense was lying near the deceased. Was lying.
27. You are not.
No recovery.
57 Maladam meeting, 57 Maladam. That is 27 Maladam. What is report also there, madam? What is report that what is report, madam?
No 27.
27, madam. 27 evidence, madam. Judicial confession matter, Manoj matter, one Kamal Bachchan Samal. ଆପଣ 9:40 ସମୟରେ ବ୍ୟକ୍ତିଗତ ଅବସ୍ଥାରେ ମୋ ପାଖରେ ଜଣେ ଲୋକ ହାଜର ହେଲା। ମୁଁ ଯେତେବେଳେ ତା ନାମ ଟିପୁନା ପଚାରିଲି, ସେ ତା ନାମ ଟୁକୁନୁ ମୁଣ୍ଡା ବୋଲି କହିଥିଲା। ପୁଣି ସେ ସ୍ୱଇଚ୍ଛାରେ ସ୍ୱୀକାର କଲା କି ସେ ତାର ସ୍ତ୍ରୀ ଜ୍ୟୋତି ମୁଣ୍ଡାକୁ ଡେରା ପାଣି ହାକି ତାର ହତ୍ୟା କରିଛନ୍ତି। ମୁଁ ଘଟଣା ବିଷୟରେ ଆମ ଥାନାଧିକାରୀ
there are the case is based on circumstantial. However, there is extrajudicial confession made by the petitioner before one of the witnesses. Recovery is also effective section 27 of the in that view of the matter, I am the petitioner is in custody since 1/11/2023. In that view of the matter, I am not inclined to the stage of limited education to limit the bail free for the court below after the examination of the material directed to give record of the evidence of the material cases, giving preference over the formal
confession evidence activity not that. Extrajudicial confession statement of the activity upon offenses
and the recovery also we working from the spot. From the spot.
Acts
from the spot. Yes, Dear my lord, the petition has been charged under section 304B, 198A, efficient for DP area. And your husband, he is in custody since 22nd March 2024. 22nd March 2024, my lord. And last time your lordship had called for the postal report. It reveals, my lord, the cause of death is asphyxia. She hanged herself. He committed suicide. Yes.
Minor. That in this case, minor, charge sheet submitted on page 624 minor. Under section 304B, 498A, 453 Act, and 306 IPC is there, minor. And that postmortem report for the cause of death of deceased is the above mentioned external indicator accumulated in nature and are consistent with the ligature mark of hanging and could have been caused by a rock and caused ligature metal rope, minor.
Anybody, any eyewitness? Anybody?
No, madam, that eyewitness.
He hanged herself.
Yes, madam.
306 is there. Right. Petition rejecting after investigation, charge sheet has been filed on.
3624, madam.
3624 for alleged offense under section
304B,
304B,
498A,
498,
306 and 4
and 4 DPM. Husband of the deceased. The medical evidence and to charge sheet reveals that the deceased has committed suicide due to unpleasant medical like unpleasant husband of the deceased and who is in custody since 22/3/2024 regarding the nature of acquisition, period of custody, and the fact that the charge sheet is already filed. Yes, next. Yes.
Yes, they record paradigm.
All practical, yes.
In this case, subsequently I came to know that notice was required was supposed to be filed. It was filed late.
The independence file and belatedly self-utilized for the purpose of
If I did based on the circumstantial evidence.
Case ID
And the hearsay evidence there.
Case ID there?
Yes, yes.
Minor, may submit. The investigator who had to granted and last to dispose the case. And kindly see the paragraph 5, the section 20. He has wrongly mentioned the one name for the last sentence. One name is Komunda, other name is wrong, that a fiction name is there. Wrongly mentioned. And the other person also mentioned that he is one of the petitioner in this case, not the your evidence. And you see, and the other name, the Sibo Sankar is one of the petitioner in this case. Wrongly, I think.
No, he is Hon'Ble.
Just get out, my kindly see the order. Protect that. Protect that.
5 weeks. But I can't correct that.
These successful disposal of
I listened to him in the same channel.
and the right time that name may be
This case is written second trial.
Last on ମୁଣ୍ଡା କରୁଛି ଯେ ଆମ ଗାଁର ସୁଦର୍ଶନ ମୁଣ୍ଡା ମୋର ବଡ ମାମୁଁ 3 ଜଣ 4 ଥର ସ୍କୁଟି ଗାଡିରେ ଥିବାର ମୁଁ ଦେଖିଥିଲି। ସେମାନେ ଆମ ଘର ସାମ୍ନାରେ କ୍ରସ୍ ପରେ ସନ୍ଧ୍ୟା ସମୟରେ ବସନ୍ତ ମୁଣ୍ଡା ଲକ୍ଷ୍ମୀପୁର ରଣଙ୍କ ମୁଣ୍ଡା ପିଟିସନ କର।
Yes, no, no. What he is saying is the 2 eyewitnesses. Who are the witnesses?
last
Last in witness. Who are they?
My lord, that Suko Munda is there, my lord.
Suko Munda and
Another is in Basanti Munda, my lord. I'm placing your statement.
and wrongly it is written Sudarsana Munda. He is
Yes,
supposed to be an accused.
My lord. That last in Basanti Munda, my lord.
Basanti Munda, na? Galat hai.
Tukulu Munda is also there. Kotakal mu am ghar pakha kotel gaur Munda.
The co-accused.
My lord, that Tukulu Munda.
Tukulu
Munda.
Tukulu Munda. Correctly just see. In regard to the bail plea of the co-accused persons, namely Govardhan Munda and Sudarshan
Doctor Munda भी गोटे last in
Isn't it? Govardhan Munda and Sudarshan Munda bail application.
Yes, yes.
Govardhan Munda
And other also is there. Three person is there.
and who
Doctor
is
They are mentioned, my lord.
not
Govardhan,
mentioned here. Here
my order is not there.
Govardhan, Sudarshan and
Say pit number 3.
Vasant Munda.
Bas.
Munda. This court, while disposing of the bail BLAPL number 3557 of 2024 on 4/9/2024 passed the following order. Okay. Mr. Parida, Learned Counsel for the petitioner submits that the petitioner, the present petitions may also be disposed of on the similar terms. However, he submits that in para 5 of the order dated 4/9/2024, there is a typographical error. The same may be corrected. There are 2 witnesses to the occurrence, namely one Sukomunda and another
Tukulu Munda.
Tukunu Munda.
Tukulu Munda.
Tukunu Munda.
Tukulu Munda.
Tukunu Munda and
Tukulu
Tukunu Munda.
Munda.
Tukunu Munda. The liberty may be granted to the petitioner to renew the bail plea. After the recording of the statement of Sukomunda and Tukunu Munda. Tukunu Munda. Liberty may also be given to renew his bail plea after the expiry of 4 months if for any reason the said 2 witnesses cannot be examined by the court below. With this observation, the petition yes. 98.
Yes, allegation of 376.
Yes.
Here the victim is a married lady aged about 30 years.
Yes.
Make this series of allegations against petitioner when the petitioner released on bail in another cases. He lost the false allegation, Your Lordship. Your Lordship, the husband of the petitioner while meet an accident, being the driver, meet an accident.
The custody?
Custody, Lordship, 16/11/2023.
23.
Lordship. And the meantime, charge sheet has been submitted, Lordship.
What are the offenses?
Offense 376, Lordship.
376. Yes.
Lordship.
My lord, that in city up to 23/12/23, my lord. That investigation is going on, my lord, as for 23, my lord. So far the charge sheet is concerned, that part is not.
And you have not filed any neither FIR nor nothing.
No, Lordship.
I don't know how will I
In
decide the
164 that victim supported the prosecution case at the age of the victim 30 years time. Yes, 30 years.
what does she say? They were in relationship.
She stated that ମୁଁ ଭଡ଼ା ଘରେ ରହୁଛି ଆଜି 4 ବର୍ଷ ହବ ଟିକିନା ମହାରଣା ମାଲଟ ପିଟିସନ ମତେ ହଇରାଣ କରୁଛି ମୋ ପିଲାମାନଙ୍କୁ ମଧ୍ୟ ସ୍କୁଲ ଯିବା ସମୟରେ ହଇରାଣ କରୁଛି ବାଟରେ ଅଟକାଇ ତାକୁ ବାପା ବୋଲି ଡାକିବାକୁ କହୁଛି ନହେଲେ ଧମକ ଦେଉଛି ତାପରେ 12-11 ଦିନ 8ଟା ସମୟରେ ମୁଁ ଘରେ କାମ କରୁଥିବା ସମୟରେ ଟିକିନା ମହାରଣା ମୋ ଘର ଆଗରେ ଖରାପ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରି ଆମ ଘର ଭିତରକୁ ଜବରଦସ୍ତ ପଶି ଆସି ତାର
Get the CD because there is nothing. You are not filing. Get the CD. Let the CD record. Yes. If you have charge sheet and all, file something.
I will get the copies.
I think I should pass a judicial order saying that no
Okay,
bail application should be listed before court without at least the FIR.
ଆମେ ଆଗରୁ ଯଦି ରିଜେକ୍ସନ ଅର୍ଡର ଫାଇଲ କରିଦଉଛେ ପରେ ଆମେ ଦେଇଦଉ
File rejection order. In the rejection order, there is nothing. How many accused is there? I don't know. Charge sheet is filed. Nothing is filed. I should pass a judicial order sometime. Or otherwise, I'll reject the bail application on that ground.
नहीं आसु आर
Couple of bail application is filed, reject. Everybody will file thereafter. That's the best way of doing it. Yes. Let me try one day by rejecting couple of applications.
Offense malot 376 2M.
Yes.
Petitioner custody malot 9/2/24.
9/2/24.
Charge sheet submitted malot 11/5/24.
20.
This is law of affairs matter malot. FIR file malot more than 2 months after the occurrence.
Yes.
Age of the victim malot 24 year malot working as a sarpanch. And
Yes.
petitioner malot is 21 year malot. And his malot he helped to the malot
Okay.
victim.
164. Read 164. Yes. ପ୍ରେମ ସମ୍ପର୍କରେ yes
ମୁଁ ବାହାରେ ବୋଲି ଆମର ପୂର୍ବ ଦେଖିବୁ ଦେଲା କିନ୍ତୁ ମୁଁ କ୍ୟାରିୟର ପ୍ରତି ସିରିୟସ୍ ଥିଲି ସେଦିନ ଲଜରେ
FIR date बताओ FIR date
FIR date है क्या 14/3/24
14/3/24 and incident
12/1/24
1/1/24 write down the petitioner is accused in FIR number so and so. The FIR has been registered on 14/3/2024 alleging an incident that has happened on 12/1/2024. During the investigation, the statement of the victim under 164 CRPC has been recorded. The victim, who is what is this?
24 years.
44 years. 24 years of age has interiorly stated that she was in a relationship with the petitioner. And the assurance of marriage, the petitioner has sexually exploited her. The petitioner is 21 years of age. Regard being head to the nature of accusation and the period of custody from 9/2/2024, and the fact that the FIR is registered after 1 month of the alleged incident, and the petitioner, the victim, admittedly was in relationship with the petitioner. I am inclined to enlarge the petitioner on bail accordingly granted. Yeah, next.
100 on behalf of Mr. Suchit Naik, one pass over.
Pass over. Which one? 100? Issue notice to the opposite party number 2. Acha, the notice was issued to the opposite party number 2. However, due to late filing of the requisites, the notice could not be issued. The requisites may be utilized for the purpose of serving notice. Release the matter after. Yes.
101. May I please your lordship? 304 offense, culpable homicide not amounting to murder Miller. Here custody Miller, 12/4/2024.
12/4/2024.
Allegation that Miller on 10/4/2024, the nephew of the informant Miller went to the village Mirchamada. On the way Miller, on the bridge Damanjodi, one Miller stone piece Miller hit on his body, head Miller. Thereafter, the FIR was registered Miller against unknown person.
Quarry.
And during course of investigation, it came to light that Lord, the said stone quarry illegally run by the father of the petitioner, Lord. And Lord, father of the petitioner stands in the name of the father of the petitioner. but the petitioner, my lord,
Illegal query. What are the offences?
304.
304.
I just, my lord, reading, my lord, two
Yes.
sentences.
304A.
While working in the store was blast mirror. One part of the store was hit to his chest mirror. And thereafter he was going to hospital and died there. That cooling mirror, eyewitness statement mirror. এই ঘটনা ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ ମାନିଆ ଗାଁର ସୁଧାକର ଶ୍ରୀ ହରିଆ ପିତା ପ୍ରତି ଶ୍ରୀ ହରିଆ ବେଆଇନ ଭାଇ ପଥର ପ୍ରାପ୍ତି କରିବାକୁ ମୋ ପୁଅ ଜୀବନ ଦେଇଥିଲେ।
Ben, ठीक है। Objection record कर दो, petitioner is accused also, and the allegation is the petitioner also. It is the after investigation, charge sheet has been filed on
my lord, 19/7/2024.
and for alleged offence under section 304 capital A and section 3 and 5 of Explosive Substances Act what is that? 1908. The allegation against the petitioner is he was running a stone quarry illegally. There was a blast in the quarry. A stone got stuck in the body of the chest, as a result of which the deceased expired. Deceased expired. The petitioner is in custody since 24/4/2024. Objection to granted bail. Regard being head to the nature of accusation and period of custody and granted bail. Yes. Pardon. Item 100 copy alert sub है last order reflected. Sorry. Late file is then that will be utilized for the serving. Don't worry. Yes.
102. May I please your lordship, madam?
CD required. CD. Call for CD.
Next week.
CD.
Fix a date, man.
Yes, date will be fixed. 103.
103.
Yes, 103. Late filing. The late filing, same code दियो. Utilize. Yes. 104.
104.
Copy.
Sir, you are in 103, sir.
103 madam.
Or the late filing of the. Are you appearing? 103.
Late filing of 8/5 copy extra copy.
Late filing or not filed?
Or not filed?
No process.
Process pilot 8/5 government has received extra copy.
No. Is it 376
pilot.
376, na?
3.
Notice was issued to opposite party number 2. You have to file the process.
And court
For service.
on 8/5/2024 extra copy was served to government.
Process is also to be filed. Requisites had to be filed. File the
Yes,
requisites. File the requisites. And the opposite party number 2 shall also be served through the IU of the present case. Please the matter. Yes.
104.
104. Withdraw. Yes, withdraw.
105.
5. Yes, sir.
Custody since 9/11/23.
9/11.
My lord.
9/11.
23.
23. Okay.
Offense is 376 2N and 6 POCSO.
Yes.
My lord, there was love affairs between the petitioner and the victim.
22. Yes. Yes. 164. Read. Yes.
ମୁଁ ଆକାଶ ମହାନ୍ତି ଭଲ କହୁଥିଲି ମତେ 6 ମାସ ଖାଇବେଳେ ସେ ଆମ ଗାଁକୁ ଆସିଲା
What's the age of the victim girl? The age of the victim girl is 17 years.
Yes,
17 years, where the petitioner is 22 years. 22 years. Regard being head to the fact that the petitioner is in custody since 9/11/2023. The petitioner and the victim were in relationship, and the petitioner is 22 years old. I'm inclined to enlarge the petition with the condition, all the conditions. Yes.
106.
Yes. Yes. Yes, sir.
At the outset, I will say that the allegation which I have gone through from the record indicates that it is a perverted mind of the petitioner. What actually happened in this case, that the informant's 2 minor sons, they were called to a temple where it is alleged that the petitioner inserted his private part on the mouth of those two bombs.
43 years.
Eh?
The petitioner is 43 years.
And two my there.
Hmm.
One is Miller's high court, one is 4 years old, 3 years old. And injury in the league also. Injury in the league.
Better.
Just I am coming to that point. I have also gone through that the background your lordship may consider here. Yes, I do. I am not saying that the allegation is simple. It is some extent graver allegation is there. The background of the petitioner is that sometimes a person was not taken proper care, he may become wayward. What happened? The parents of the petitioner died at the early age. Thereafter, he was moving here and there. Some other, he started a cycle repairing shop in the footpath. Maybe I cannot say perversion started against the society, maybe the entire thing. And so far, his previous conduct is concerned, as it is reflected in the case record, that there is no previous incident of any sort. So this is the background. Keeping in the background, sometimes a person may be made criminal due to the circumstances. So whether we will give him a chance to reform or say that he will remain behind the bar and face the trial, that
should get a chance of reform after the examination of the witnesses. Right. Regarding head to the nature of allegation and the fact that the petitioner is a 43-year-old man and the victims are
victim boys, 2 boys.
7 years and 4 years. I am not inclined to enlarge the petitioner on bail. However, liberty is granted to the petitioner to renew the bail plea after the material witnesses in the present case.
Your lordship, material means 3 witnesses, the informant and the 2 sons.
Material witnesses. And the trial court is directed to do well to see that the material witnesses are examined, giving preference over all the formal witnesses. With this observation, the petition is disposed of. Yes.
107.
Yes. Yes.
Petitioner sir custody since 27/3/2023.
27/3/2023
lordship, 1.5 years lordship. The offense 20B 2C of NDPS Act. 78 kg of gun. 78, my lordship. And the seized from the Skoda vehicle, lordship. And the petitioner's number 1 with the driving the vehicle, he is 26 years old and petitioner 2 with those passenger.
Criminal antecedent?
No criminal antecedent, lordship.
Investigation is going on. After it is not with me. What I have received, Miller. From the exception of conscious position, 2 persons in vehicle Miller were arrested. They all are from the BR. Petition sent to the concerned police station to obtain criminal antecedent. These are from BR.
Wait.
That's it. Submitted all.
You have 2 points in your favor. One is less than 100 kilo, and second is you are in custody since more than 1 year and a half. You are entitled, but he has to get the.
Only one thing is my lawrence, my senior said that charge sheet not submitted, but charge sheet submitted.
Me, not
Yes.
submitted. Not
I have given all the police paper, lordship, with charge sheet, everything, lordship. Final PR, everything I have given.
So he has to seek
No
criminal.
No criminal antecedent, lordship may consider lordship, young pilla.
The prosecutor is not entitled to get
Yes, lordship. City Mogga.
Show me your affidavit. You have filed that no criminal.
No, in my petition, I have stated that I have no criminal antecedent.
No, let him verify it because you are from Bihar. Therefore,
Otherwise,
you need not argue. I would have given.
Yes.
Less than 100, I am granting bail.
Yes,
no
sir,
problem. Wait, let him get. You get the CD and antecedent. 1 week after. 1 week after. Give it 1 week. Let it counsel for the state to seek instruction regarding the antecedent of the two accused persons and up to date CD. Up to date CD. And then counsel for the petitioner submits that the recovery is only 78 kg of contraband ganja, and they are in the petitioners are in custody since 27/3/2023. 2023. Please the matter after 1 week. Yes.
Date your last month.
No date will.
Obliged.
9. Please take it off.
Yes. Yes, madam.
The alleged offense is under section 420. The petitioner was an LIC agent. Now he has been terminated. I'd filed an application for disabled, saying that he's a disabled person with 80% disability. And my my lords had directed the learned counsels for the state to take instructions with that to that regard. In the meanwhile, your lordship, the allegation is this.
Petitioner is already returned a sum of rupees 8 lakh,
Lordship.
which includes 1,65,000.
The allegation
And it
is
has been admitted by the University IU. Part of the money has returned.
Lordships.
Part of the money has returned.
Lordships.
8 lakhs from what?
No, 12
lakhs.
12 lakhs.
12 lakhs, 11,290.
12 lakh, 11,297.
Out of that, 8 lakhs he has already paid.
Lordships.
And last week, my director अपने instruction mirror regarding the discharge the Federal offering.
Yes. You are in custody since?
I'm in custody since my lords on 21/4/2024.
21/4?
2024.
What is the disability you tell?
Locomotive, your lordships.
No. I am granting bail.
Yeah, that is correct. That is also correct.
Right.
Take 80%.
That is petitioner is accused in the FIR number so and so. Allegation against the petitioner is so and so. It is reflecting from the record that the petitioner has returned about 8 lakh rupees to the informant, out of 12 lakh 11,297 LS defrauded amount. The petitioner is a disabled person, and on the pursuant to the order of this court, the office of the IIC Titlagar has submitted a report dated 10/9/2024 inter alia stating that the petitioner is a locomotor petitioner suffers with locomotor disability, and inter alia stating age under ABC regard being had to the period of custody from 29/4/2024, nature of allegation, and the fact that the petitioner is a disabled person, apart from the fact that the petitioner has already returned about 8 lakh rupees to the informant. I am inclined to enlarge the petition on bail accordingly. Granted bail.
Pleasure.
Bail over. Okay.
The case of the prosecution, my lord, is that, my lord, petitioner, if the member of the tender party, my lord, has selected a person without following the due procedures as prescribed under the code. That is in short the case. My case is, as DSWO, I invited tender. After receipt of the tender papers, I placed it before the ADM with the chart, and ADM and collector. Collector was absent on the day. He has entrusted ADM to go through the papers, and finally a list, everything was prepared, and person concerned was given the tender, madam. No allegation from my office that I have committed any mistake. But the vigilance people
it is a single tender bid.
My lord.
Single bid.
Madam. And my lord, when audit was done, prepared, my lord, the auditors asked for to held up the amount, some amount, and that was also held up by the office.
neither any departmental proceeding has been initiated against me, or now in between, my lord, I have retired. Nor any action has been taken. Everything was perfect. My lord, if I don't know, my lord, whether my learned friend has obtained the records or not, but I was going through the records of the office, my lord. Their first allegation is collector is the person who should have done it, approve it. But if my lord would see the order sheet maintained in the office of the collector, the note sheet was placed before the ADM stroke collector, and what ADM has written, my lord, I think he must have got, my lord and friend must have got it. Since collector was, my lord, notes above, note was placed before the collector. Since collector was busy, otherwise, opened the tender on 27/10/2001 at 4:10 p.m. in presence of the tenderers and DSWO in my office chamber. This may please be approved as ex post facto. Besides the comparative statements made by the office may also be approved, which is placed below.
Yes.
And the comparative statement is also there, and person who has been entrusted, he is the lowest tenderer. Their allegation is the person concerned has got no facilities or systems to do the work which has been entrusted.
This is you filed a 239 application jointly with other accused persons?
No, single.
But the order says that it is joint
The
application.
order melody entire cause title of the accused person, name of the all the accused person.
No, come to page 34. It says that
page
the petition dated so and so.
Page
Oh,
34.
separate application and decided in a common order. Decided by the trial court by common order, but the applications were moved separately by all the
There,
accused.
my lord, if my lord may kindly see the order impugned at
Yes,
page
34.
20 page 23. Perhaps my lord is
Page 34.
no, my lord, that. I think
Page 35 is the actually operating portion. Which
35,
which
yes.
carries the reasons for which we
No. My
34.
brief,
Page 35 of the.
my brief is my lord, perhaps
34 is the impugned order.
Yes, my lord.
3/8/2018.
The regions he ascribed, that starts from
my
page
lord,
35.
I don't have, I have no paper.
No, it has
It
35
is your
is-
petition. That is annexure 5.
My lord friend is holding my lord.
first case.
Kalika Prasad Das, 770.
I'm holding that.
770. My brief is my lord 703.
No,
Okay,
first case has the right.
Okay.
First case is 7.
Kalika Prasad. You are Gayatri Pradhan.
I'm Gayatri, sorry.
Okay.
I'm not Kalika.
Yes.
Kalika Prasad Raj.
The same.
Kalika Prasad.
No.
Kalika Prasad, somebody else.
I'm not sure if that is.
Yes, I am for Kali Prasad, Lordship.
Yes.
Yes,
Mr.
I
Mahapatra.
Mahapatra.
He was seeking an adjournment. Yes. Seeking an adjournment.
In fact, the petitioner is the ADM actually. Kali Prasad was the ADM on the opening of the document. In absence of the collector, he was the ADM. So he had to discharge the duty instead of the collector.
If you are ready,
So these are the small.
Are you ready to argue?
Or Mr. Mahapatra.
No, Your Lordship, I don't have the brief. I have some facts with me. Just wanted to share with you.
We will not waste time then.
Then will not.
No, Your Lordship.
At the request of the counsel for the petitioner, lease the matter after 2 weeks. Entering order to continue. Yes.
For final hearing, Your Lordship.
Final hearing.
Oh.
Get ready. You have a tough case.
Yes, Your Lordship. Fixed date, sir, Lordship.
Now date will be fixed. Yes.
Obliged.
May I please, Your Lordship?
Yes. 40. Yes. You are at 48. Yes.
Not. I'm submission, my lord, that I'm assailing the order framing charge. I mean, rejecting the application for discharge, my lord.
Yes.
Only 2 count, my lord. That, my lord, in the wake of due to death of the complainant, the bribe giver, the entire prosecution suffers from epilepsy or establishing that demand. Demand is the sine qua non in the case, as your lordship last case I was sitting you wrote. Even if presumption section 30 applies after demand is proved, as your lordship was few days before spacing.
Bhavane, we don't mind. Item 48, copy may be given. Copy already. They should give it.
No, he only says that the complainant has died.
Right.
So how will you prove demand? That's what he says. So therefore you quash it. That's what he says.
That point is no more resident in that particular case. In
Because
the
there
case-
are other corroborating evidence may be there. You get it.
Even
That
the
is not-
date of the decoy.
This is one ground.
And second part of my argument for lordship would be that the public servant was not within the domain of the word for forbearing the favor to the bribe giver.
That is also.
And then I'm coming.
Mhm.
That the complaint, the allegation that stems from the complaint is the bribe giver requesting the public servant present petitioner for making a request to the higher up who will authorize to grant loan, sanction loan.
That is section 7.
Yes, exactly.
Therefore,
That is section 7.
that definitely section 7, maybe fall within section 13, illegal gratification.
Whether in position or
But
not position.
Not position. So he is
That's
not
section 7.
he is not
On your behalf or on behalf of anyone.
That's section 13. But 7 is there must be demand and accept receipt. One, unless and until demand is proved, notwithstanding the recovery.
Do you have you don't have any papers with you? Supply the paper. You only address on the question of demand. If the demand in fact is not there, then he may have a
Yes.
case. Why to suffer the trial?
Yes.
If you can't prove the demand.
It may be ended in fiasco.
If you have any material to prove
Okay.
demand, then he has to face it.
Problem. That is so.
Yes, please. Only demand part. Just check it. Give a copy.
And in
Please-
the wake
please
of
have to
death,
one week.
in the wake of,
Yes.
yes, I made an application. Kali ki achhi se court re try.
No.
We'll make an application.
No. Then argue it. Let me be satisfied.
Last time.
Argue it. Where is that? 49. Argue it. 48, na? 48. See, this petition was filed when? Once stay is granted, then it will be.
Copy deba koi question.
ঠিক আছে ଆପଣ কপি ଆପଣ প্লেস করুন
That is the place.
You argue. I'll just see that. Yes.
only my submission recorded.
Yes. To me.
My humble submission that the learned.
What are the allegations?
Allegation is this that the bribe giver, the complainant, requested the present petitioner to request the authority higher up for sanctioning loan. That is this only allegation. For which
you are working as what?
Yes. I'm working as the affair is assistant, dealing assistant. Dealing assistant.
Yes.
So, Annexure 17 is the affair. So the bribe giver requested me to see the sanctioning of loan by the higher authority, for which the complainant alleges that
Is the prosecution is precluded to lead secondary evidence to prove demand? The primary evidence through the informant. He has died, no problem. But they have option to prove otherwise. If they can't prove, then they'll face it. You will be acquitted.
Then there is no other option.
Can that be a ground for discharge?
In the absence of any circumstance, in absence of the entire prosecution, conspicuously absent to establish a circumstance wherefore the court, the honorable court.
That is their headache. The onus on them to prove. Onus on them to prove.
I guess there is no material. Had there been material, then matter would have been different.
Yes. Yes.
And due to the death of the informant, so the
Come to the charge sheet.
That's it.
Charge sheet.
That's it. The file going. Can you input order record? Then the Learned Trial Court has found.
Show me the charge sheet.
Charge
You
sheet
want
I've not filed.
discharge, but there is no charge sheet.
I have not filed charge sheet.
And
So
but
then
you
I'll
need
file.
discharge. Without filing charge sheet, you need discharge.
May I submit one thing, my lord, if my learned friend, and he's like
Next week.
Lord. let him have the liberty, my lord, to raise all those points, my lord. Because these are the defense grounds.
Yes, that those
Can be raised,
liberty I'll
can be
give.
raised. And a trap case, my lord, it's
That's
very
liberty I'll give.
difficult to wriggle out. In a trap
Can't
case,
go
sir,
into all
it's
this.
very, very difficult to wriggle out.
And eventually I'm going to do the same thing.
I read that I filed an application for discharge. The Hon'Ble trial court has torn
That's
out.
right, but
Then your lordship, say, I will raise all the point.
yes.
Great, great.
Let
I'll
call for
consider.
the petitioner. In the present petition is seeking quashing of order dated 31/7/2024, passed by the related special judge Vigilance Cuttack in TR case number 38 of 2011, whereby his application under section 239 CRPC, CRPC seeking discharge, has been rejected. This is a trap case. Then counsel for the petitioner submits that the informant decoy has already expired. So therefore, in the absence of the evidence of the informant, the demand aspect of the allegation cannot be proved by the prosecution. So therefore, subjecting to the petitioner to the rigors of the trial would be definitely a futile exercise. On that ground, he seeks discharge. And land counsel, Mr. Das, land counsel for the petitioner, submits that even in the absence of the informant, the prosecution has the option of leading secondary evidence to prove the demand aspect of the matter. Be that as it may, I am not inclined to enter into the merits of the case. Rather, I am giving liberty to the petitioner to raise all the points before the trial court at the appropriate stage. If such a plea are taken before the court below, the same shall be dealt with in accordance with law. With this observation, the petition is disposed of. Next. Yes.
Whether the secondary evidence is there.
They will face it, secondary or primary, whatever. Yes.
54.
That is, I have recorded his statement only. Yes, sir. Yes. Yes. 54. Is there? Nobody is here. Offense?
My lord, 306, my lord. My lord, something has been.
Despite second call, non-APS for the petitioner in the interest of justice, urgent to November last. Yes. Next.
65.
No, don't fix the date. Either argue, otherwise it will go to November.
He's suffering from
Whatever. Adjourn on the request adjourn.
74.
Is there?
Yes, ma'am.
Even after in the second call, non-APS for the petitioner. Hence, in the interest of justice, adjourn the matter to November last week.
84.
May I please? It's a case under section 370 by 34 of IPC. In the meantime, my lord,
Sorry?
case turned to 376D and other allied offenses.
376D.
Last occasion, this honorable court has been
Sorry?
pleased to call for the 164 statement of the victim on last occasion.
Yes.
Notice of
Notice served.
notice.
This is notice.
763 is.
Notice on. Requisites you have not filed. Current counsel for the petitioner has not filed requisite to effect service on opposite party number 2. Let him do so during the course of by tomorrow. And the informant of the case may also be served through the IO of the case. Leaves the matter after 3 weeks. Yes.
86.
May I please? Once. In this case, my lord, the charge sheet submitted under section 304B, 306, 494,
20?
and section 4 of DP Act, 304B, 306.
Yes.
My lord. And the cause of death is, my lord, taking poison, my lord.
302.
304B and 306, 498.
306. Okay.
Charge sheet submitted.
Custody since?
Custody 10/5/2024.
Custody since, my lord, 18/3/2024.
3/4/24.
Custody?
Custody since 18/3/2024.
18/3/24.
24.
10/5/24.
Okay.
Rejection 3/4/24.
3/4/24. Ideally, you should go to trial court.
Your lordship may kindly have a glance to the charge sheet, my lord.
Oh, show me.
In the charge sheet, my lord.
Died postmortem report.
How she died, my lord, your lordship. Statement
Read
of
it,
the-
read it.
The relevant portion I have marked.
You don't have a copy. You don't have a copy. Very nice. Read it.
Yes, my lord. Relevant portion, my lord. On 26/20/22. Charge sheet. Every type of charge sheet. On 26/6/2022, Mandodari Sabar went to Majhigori Temple, Raigada. Since they shifted the, sorry, ma'am. Notice unconscious by some owner of the Majhigori Temple. She was declared dead. Sorry, ma'am.
You file a copy.
Yes,
Let
ma'am.
go-
The statement under
let
section.
Counsel for the petitioner seeks 1 week time to file the copy of the charge sheet. Let him do so, release the matter after 1 week. You should get a copy.
Just
Whatever you are reading, I could have seen it. And you would have given a copy to him also.
Charge sheet is there.
File a copy. 1 week after, 1 week after. Yes. Next.
91. My lord, in this case, the petition already been came and my name already been reflected, but author's previous counsel, mane advocate name will not be deleted, my lord.
Oh, okay. So what is this matter? Tell me first.
Matter, I have filed the interim application also today.
No, you ask, argue on merit, main matter.
No, I have filed the interim application today. Mane filed the interim due to his illness of his wife.
You don't need regular bail.
No,
You
no.
satisfy me if you are
No,
entitled.
no, I am not interested in regular bail. I have filed today interim application, but number has been given, not given me. So kindly allow me 1 week time.
Sir, what I'm saying is you argue on merits in main case. If you are entitled to regular bail, I'll give regular bail. Why are you worried about the interim bail? Let us see whether you are entitled to regular bail or not. If you are not entitled to regular bail, then I will think of interim bail.
I am not getting the file, my lord.
Oh,
Now, first time I have applied.
Okay, you collect the file, I'll put it in after 1 week.
Yes, my lord.
After 1 week.
Yes, my lord. Other counsel.
You prepare in the main case. If
Yes.
you are entitled to regular bail,
Yes.
why are you trying for?
Yes, my lord. Yes, my lord.
Yes. After 1 week. Yes, next.
Another previous counsel name should be deleted.
His name.
Previous counsel.
Previous counsel name. Yes, next.
110.
110. Brief has been transferred from the chamber. Therefore, this may be deleted from the court list. It is directed to verify whether any other counsel has entered appearance.
4, 5 time malad sattu
Huh? On the last date of hearing, the learned counsel for the petitioner submitted that the petitioner has taken back the file from him. Therefore, he's recused himself from this case. Raise was directed to verify whether any other counsel has entered appearance or not. It appears from the record that none has appeared appearance on behalf of the petitioner. In view thereof, it appears it seems the petitioner is not interested to prosecute the matter. Accordingly, the petition will be dismissed. Yes. Next.
111.
111. Non-appeared. Last time also non-appeared.
Hello.
Right on. When the matter was taken up on 5/8/2024, none appeared for the petitioner. Even today, on the second call, none appears for the petitioner, and therefore it seems the petitioner is not interested to prosecute the matter. Accordingly, the same is dismissed. Yes.
Quashing of cognizance, my lord. Last time, my lord, on 12 to
112.
So direct me to take instruction.
112.
My lord. No, 111.
Oh, 111 I am dismissed of.
My lord.
Yes.
May I please, your lordship? May I please, your lordship, lord?
Issue notice to opposite parties. Just see. Service complete.
Postal address is refused.
Address is refused.
Another opposite three address is left.
True IO? True IO of the case. notice insofar as the opposite party number one is concerned. No, this is arising out of ICC case, no, criminal.
1cc, my lord.
1cc case.
133 nuisance, my lord. If your lordship permit me, the instruction is the matter between the dispute between the mother and the two daughters relating property. The present petitioner was running a business, having a shop over the plot that belongs to the landowner is the mother. Then the daughters quarreled with the mother. They locked up the shop. So the customers and myself was trouble. So the 133, the initial first court directed Tahsildar to take the protection of police and to unlock the shop so that I can vacate my jewelry shop. But that order was challenged by the daughters, and the revisional court said that this is not 133 cannot be involved, and the court has no jurisdiction to give such direction. My humble submission that the revisional court is wrong, because any nuisance is a wide open. That the obstruction to the customers to come to the shop and
show me the revisional court order.
Yes. My invite lordship kind of page 31. 31, my lord. Paragraph 6.
31, paragraph 6.
This has been strict contrary to the first court order.
Yes.
Section 133 of CRPC deals with removal of nuisance. The provision itself clearly mandates that the nuisance referred to therein is nothing but public nuisance. Section 268 of the CRPC defines public nuisance as an offense against the public that causes injury, harm, or even annoyance to the general public in the enjoyment of their public right over a common area. It has nothing to do with the nuisance affecting any person, individual capacity. So the present petition is a shop, and he is discharging duty.
Yes, who is appearing for?
Notice appear corner.
No, state. He can assist me.
Once in a nuisance.
Nuisance. And you have not completed the state. You have not completed the state.
Only first court has given direction to Tahsildar.
What is the service report you said? One, insofar as the Arati Behra is concerned, what happened?
1 and 2. Addressee refused, and opposite 3, addressee left, hence returned to center.
Addressee left. Who is the Lakshmi Priya Behra?
Lakshmi Priya Behra is the landowner.
Mother. And Bharati Behra and Arati Behra are the sisters.
Daughter of the
sisters. Okay.
Daughter. Yes.
And sister, you are sister.
No, I'm the shop. I'm the running a shop in the plot, tenant.
Who is the landowner?
Landowner Lakshmi Priya. The mother is the landowner.
Okay. Then service is
again.
Take first step and stay up for the stay.
Only Tahsil lordship say matter has been compromised.
To serve the opposite party number 3.
Through police law.
Through IIC, which?
Yes.
IIC. Let the notice on the opposite party be served through IIC.
Town PS.
Huh?
Town PS.
Town
PS. Kendrapura Town PS.
Kendrapura Town PS. 3 additional setup for people.
Yes.
I'll supply. 3 copy. 3 copy दे दियो और 3 set करिए and after 1 week. You try and serve after 1 week we will quash it. There is nothing. Yes, sir.
113.
Yes.
Yes, my lord. I'm appearing virtually, my lords. In item 113, Mr. Panda is to appear in this matter, my lords. He's on his legs at the moment. I pray for a short pass.
And request adjourned. Yes.
114.
My lord, that demat account, I have been able to collect the saving account. I have given the details. I have served the copy on the other side also.
Yes. Will you verify it? Next week? Okay. The details of the savings account which is attached to the demat account has been of both the petition have been supplied to the Learned Counsel for the Vigilance, Mr. Das. He seeks 1 week time to verify the same and report it to this court. Least the matter concerned. And only you verify whether this account is
Nothing is coming that I have not filed any written note of submission, but in the earlier I have generated in the court. Today I am.
written note of submission filed today by Mr. Das is taken on record. Accordingly, the noting in the cause list shall be altered. Yes.
115. Refreshing your lordship's memory, that matter where the marriage has been declared null and void, and I have filed the petition for quashing of the entire proceeding. Last time your lordship was pleased to direct the state council to once again to take step for service of the notice.
Yes, my lord. My lord, the IIC, my lord, Markot PS, my lord, he has went to the house of the given address, my lord, but nobody is present there. Thereafter, my lord, her parental address, mother's address at Sambalpur Modipada. There, my lord, the IIC town PS Modipada, he visited the house, my lord, nobody is there in the house, my lord. Could not found Simati Suddha for inquiry about her from the local people, namely Sudhir Ranjan Bohida and Prashant Kumar Kaur and others, but no one could identify Srimati Sudhakar. Hence, I could not serve the notice.
How many days will you? Well, cause it.
My lord.
Why have to cause it now?
But the earlier occasion, my lord, the notice also served through IIC, my lord. But IIC, my lord, unable to serve since the victim is not available in.
See, what happened is they applied for divorce and divorce has already been granted, ex parte. It was not challenged.
Not divorce, my lord.
Yes, nullity of marriage.
Nullity of marriage.
Yes, nullity of marriage, not divorce. Okay, section 12.
Yes.
It has been declared, the marriage is ex parte. She has not challenged, it has attained finality. And now this FIR, she is not available.
I think there are direct decisions of appeals court, my lord. If the marriage is in null and void, then for it will not.
I love that decision is with me online.
I'll quash it or relying upon that.
So copy them. Now copy now.
Right. The matter was taken up for hearing on 2/9/2024. The following order was passed. Pursuant to the aforementioned order, the IIC Market Nagar PS had further attempted to serve the opposite party number 2, but the service could not be effective because none was available in the given address. In view thereof, this court feels appropriate to decide the matter by giving opportunity to the state council to argue the matter. Mr. Sujata General and Council for the petitioner has relied upon a judgment of the Honorable Supreme Court reported in so. So which paragraph?
Hello, last next.
And null and void interception. Yes. Declared upon the para 7 of the judgment which reads as under. Relying upon the judgment, Ms. Jana submits that since the marriage between the petitioner and the opposite party number 2 has been declared to be nullity by the family court, which court is that?
Family court Kotak.
Family court Kotak, and the said judgment remain unchallenged, as a result of which it has attained finality. Therefore, the criminal case initiated by opposite party number 2 against the petitioner for offence under section 498A, 294, 506, 34 IPC, read with section 4 of NDPS is not sustainable. I am completely in agreement with Mr. Jana. accordingly, by relying upon the judgment of the so and so and relying upon the judgment of Supreme Court in Yansing and so and so, I am of the view that subjecting the petitioner to the rigors of the trial in the present case would definitely a futile exercise. Therefore, I am inclined to allow the present petition. Accordingly, the FIR so and so and consequential punishments are caused. Yes. Next.
My lord, bless.
Yes. If anybody there from the other side?
My lord, urgent copy of the
Urgent.
docs. Oblate.
Yes.
No one is there from the revenue vessel, and it is a cover judgment of my lord.
No, 3 o'clock I have said, so that let us wait.
My lord. And wait.
Another 10 minutes. Yes. Yes.
17. My lord, I have prayed here for quashing of the entire proceeding.
Yes.
My lord, I'll just flow my case in. And originally, your lordship may kindly turn to page 9.
9 years.
1cc case was filed. Who are the accused persons? Your lordship may kindly see page 9. Is Barun Chandra Pradhan and
No,
Dr.
this was an FIR.
Originally 1cc case,
156.3. Yes.
FIR. Your lordship will kindly see the cause type.
Your name is Anil Pradhan.
Dr. Anil Pradhan.
Yes.
Barun Pradhan was the owner of the land, who is not no else but my father. The allegation is that we, both of us, father and son, duped the complainant and misappropriated the money. This is the entire given. Now, your lordship,
what is the which appropriate amount?
My lord,
According to the complaint.
14 lakhs.
14. Okay.
14 lakhs.
Yes.
This was the allegation. Now, your lordship may kindly turn to this document in which annexure 2 at page 32.
Yes.
The land was exclusively recorded in name of my father, Barun Chandra Pradhan.
Barun Chandra Pradhan.
Barun
Yes.
Chandra Pradhan.
Yes.
Sale deed was executed under annexure 3.
Annexure
3.
Okay. Sale deed your father executed in favor of?
My lord, your lordship may kindly turn to page 38. বিক্রেতাঙ্ক নাম দাম বরুণ চন্দ্র প্রধান, ক্রেতাঙ্ক নাম দাম অশোক কুমার গিরি.
Ashok Kumar?
Giri.
Giri, yes. He is the complainant.
He is the complainant. Sale deed was executed. By virtue of the sale deed, mutation was also allowed in favor of Ashok Kumar Giri. New record of right was created under annexure 5 at page 52.
Yes.
Your lordship will see Ashok Kumar Giri, and in below your lordship will see Dakhal Kharaj case number 481/2021.
Okay.
That order also have given
Yes.
at page 54.
Yes, that order is there.
Mutation case number 481/21.
Yes.
It was allowed. Now, my lord, after the recording was made, he filed the complaint. In the meantime, the original vendor, Barun Chandra Pradhan, died. GR case was instituted, in which I was put under arrest. I was released on bail.
No, what was the allegation?
Allegation that I have cheated him.
Cheated because your father has already registered.
Registered deed is there. Mutation has been done in his favor.
Allegation is not on that. Allegation is that regarding the possession.
He's not giving possession.
Not giving possession. That is only the source.
My lord, mutation.
But where is the criminal case then?
My lord?
Where is the criminal case? You file a suit for recovery of possession.
My lord, that is correct. But only that allegation what I have.
Possession. What is this criminal case?
My lord, once mutation is done, it is presumed.
Title is not doubted. Title has already been perfectly transferred to the complainant. And the original owner, the father of the petitioner, he has died. And the allegation, according to you, is that he is not giving possession now.
Only that allegation.
There are civil remedy for that.
161 only a 2 lines.
Where is cheating?
161 you also was issued notice to the.
Where is cheating about?
On 21/12.
What is the service position there?
He has received notice. Notice is sufficient.
Repeat.
Their intent,
Council has appeared already.
their first intention was to put me behind bars. Their intention is now
And
satisfied.
even then you are not willing to give possession.
My lord, mutation itself shows it is a possession. Mutation
But in the
was,
ground, what exactly happening? Why don't you give possession?
my lord, who am I to give possession? Your lordship may see the cell deed. দখল থাইকে সম্পত্তি কিনিলি
And I'm reading two lines. sir.
আরে কবলারে যা লেখা হইতব সেটা হবো না সিএ স্টেটমেন্ট
Paper possession has been given, but otherwise possession you are not giving.
Physical possession. And only 2-3 lines, madam. যে ସମୁଦାୟ ଜମିରୁ ଆମେ କିଣିଥିବା 9 ଡିସମିଲ ଜାଗାରୁ ଏ 18 ପେଜ କମ୍ପ୍ଲେନାଣ୍ଟ ଷ୍ଟେଟମେଣ୍ଟ ଆରଆଇ ଅମିନଙ୍କ ଦ୍ୱାରା ଚିହ୍ନଟ କରାଇ ପାଚେରୀ କରିବା ପାଇଁ ଲୁହା ଛଡରେ ପିଲର ଉଠାଇ ଦେଲୁ ସବ ରେଜିଷ୍ଟ୍ରାର ଅଫିସର ଚମ୍ପୁଆରେ ଜମିର ରେଜିଷ୍ଟ୍ରେସନ ସରିବା ପରେ ମୁଁ ଓ ମୋ ବାପା ଜମି ଦେଖିବା ପାଇଁ ଯାଇଥିଲୁ ସେଠାରେ ଦେଖିଲୁ କିଛି ଲୋକ ମିଶି ଆମ ପିଲାର ସବୁ ଭାଙ୍ଗି ଦେଇଛନ୍ତି ଏବଂ ଡିମାର୍କେସନ ସବୁ ଲିଭେଇ ଦେଇଛନ୍ତି ତେଣୁ ଉକ୍ତ ଜାଗାରେ କୌଣସି ପ୍ରକାର ଝାମେଲା ତଥା ଲିଟିଗେସନ ଅଛି ବୋଲି ଆମକୁ ଜଣା ପଡିଲା ଏବଂ ଆମ୍ଭେମାନେ ଠକେଇର ଶିକାର ହେଲୁ ଉଭୟ ଚମ୍ପୁଆ ଥାନା ମଙ୍ଗଳପୁର ଗ୍ରାମ ଅନିଲ କୁମାର ପ୍ରଧାନ ତାଙ୍କ ବାପା ବରୁଣ କୁମାର ପ୍ରଧାନ ଚଞ୍ଚକଦା କରି ମୋତେ ଠକେଇ ଦେଇଛନ୍ତି ବାରମ୍ବାର
somebody else breaks the demarcation line.
You have stay in your favor.
Malo?
Stay in your favor.
Yes.
Stay. Let the stay continue.
ବାରମ୍ବାର କହିଲେ ମଧ୍ୟ ଆମକୁ ଭୋଗ
None
ଦଖଲ
appears for
ଦେବୁ।
opposite party number 2. Despite service, by way of last opportunity, the matter is urgent to such and such day. If the opposite party number 2 doesn't appear on the next date appearing, the matter will be decided in his absence. Release the matter after 1 week. Interim order till then shall continue. 1 week for a year, otherwise I'll decide. There is nothing.
Interim order dated
Interim order.
21/12/22.
One interim order dated 21 so. You are on bail, na?
Yes. Malo, bail I was granted in trial court. His entire intention was to put the doctor behind bars so that he loses his job. He has lost his job. Now this Damoclean sword is being hanged. In the meantime, Malo, what is the law on the subject? In mutation manual, once the mutation is done,
I know, I
it's
understand.
deemed that he is in possession. Or else the mutation could not have been done.
Otherwise, he has to file a suit for
Yes.
recovery of possession, if at all. Yes.
Keeping this Damoclean sword hanging, he wants the arms twisting method.
Yes. Next.
118. I am for the opposite party, your lordship, in this case. May it please your lordship, I am for the petitioner in this. Just a minute. There is a talk of compromise going on between the
Yes.
parties.
What do you say?
Now,
What do you say? Whether you are trying to settle?
I am for the father in this case. The case is that the
I am not asking on merit. Are you going to settle? He
Yes,
says
my
that
lord,
there is a talk going on.
if communication talking will be possible, then certainly we will.
Then council for the parties conjointly submit that they are there is a process and the settlement process is going on. Hence they seek adjournment, release the matter after 2 weeks. Yes.
Interim order may be
Interim order to continue. Yes.
obliged.
119.
By
Service on the opposite party there is complete despite service no notice nobody appears. Prisoner. Yes. Pass over at this time, 3 o'clock. Urgent. On the request of petitioner, counsel for the petitioner. Service complete. Non-APS for the opposite party number 2. You are opposite.
My
party.
lordship, I am from
Also,
appellant.
and-
I am for appellant, sir. I am for the appellant, appearing for the appellant.
Yes, madam. Tell me.
Yes, the council actually is very much sick and I'm praying for 2 days time only.
On the request of opposite petitioner. ठीक है. तो नवंबर में बोले था.
Hello. My name, I am appearing on behalf of the OP.
Okay. Yes.
My lord, after knowing the fact that one order has been passed by my lord, that I have appeared so moto, and the petitioner has not given any copy to me. So my lord, direction may be given to him to supply a copy.
He says that he is appearing suo motu on behalf of opposite party number 2.
Notice has been issued through court.
Anyway, he.
I'll, Chair, there's no issue.
What are the offenses?
Her daughter filed a case against the mother, brother, sister, nephew, niece. First 1cc case, magistrate directed a 156(3). Police investigated the case, filed final form saying that no case is made out. Then protest petition was filed. On the basis of the protest petition, cognizance has been taken 241, 292, 294. These are all, mother is 78-year-old, daughter has filed a case against the mother, brother, sister, niece, nephew.
What does she want basically?
But there are 2 civil suits pending.
Why don't you go to mediation?
Mediation.
Oh, Jaipur, sir, no problem.
I'll stay the proceeding, go to mediation.
The proceeding has been stayed, my lord.
Go to
There's a
mediation.
order.
See, since he is there, yes, Mr. Nando,
My lord.
you are the daughter, you
No,
are
no,
litigating.
my lord.
You are not the daughter.
I'm the sister. I'm the sister.
You have filed a case against your own mother and
No, my
sister, brother, and everybody.
No, my lord. I'm the sister of that old lady.
Sister of the own lady.
Yes, my lord.
No, you are 1 minute.
Mother.
My lord, Anuja
Who is,
Panda.
1 minute, 1 minute. Who is Vijay Lakshmi Tripathi? You tell me.
Yes, my lord.
Vijay Lakshmi Tripathi.
Mother of this.
That's what I'm saying. Why are you saying sister?
No, my lord, there is a dispute in between the sisters and brother.
Whatever, you being a sister, a daughter, how can you file cases against your mother who is 76 years old?
They have criminally assaulted me.
No. See, I'm referring you to the mediation. You advise your client to settle the dispute on mediation. If you don't do, I will quash it. I'm making it very clear.
No, I will advise my client to.
On merit, I'll quash it if you don't settle the dispute.
Yes, ma'am.
Take
Yes,
it
ma'am.
from me. How can you litigate against your mother like this?
Well, so many civil cases are pending in between.
Whatever, I'll quash it if you don't settle.
Yes, my lord.
Yes, you please advise your client that this is the view of the court. You please settle.
My lord, if the settlement in the permanent local Balesar, that will be comforted to all the parties.
Where? Balesar. Balesar, let it be Balesar.
Yes, my lord.
Let it be Balesar.
Both the parties are belongs to
Balesar. I don't. The opposite party number. Okay. Mr. Amar Vallabh Nando, Legal Counsel for the opposite party has entered appearance and filed Wakalatnama and submits that he doesn't have the copy of the petition. Mr. Sarma undertakes to supply the copy of the petition to Mr. Nando.
Let him give the details, email, whatever.
Mr. Nando. You please give your detail, email ID and all, he will give it. Okay.
Yes.
It appears that the opposite party number 2 is the complainant is the daughter of petitioner number 1 and the sister of petitioner number 225. 23.
4-5 are niece and nephew.
2-3 and the maternal aunt of petition number 4 and 5. This is a dispute in the family. Therefore, I am of the considered view that the parties should be relegated to the mediation center of district court Baleshwar. Accordingly,
district permanent local.
Yes, Baleshwar. When can you appear? You tell me that the parties are directed to appear before the mediation center, district mediation center at Baleshwar on 17th. 17th?
Yes, ma'am.
On 17th of September 2024 and explore the possibility of a settlement and awaiting the report of the mediation center, lease the matter on such and such day. After you lease the matter on again 23rd. 23rd the interim order to continue.
Order dated 4/5/2023.
4/5/23 shall continue till the mediation takes place. Yes.
Yes, my lord, obliged.
You please, Mr. Nando, you please give your email ID or whatever. What is your phone number? You tell me.
943800.
No, 1 minute. You write down Mr. Sharma's number.
Yes.
Write down.
98.
Doesn't have a pen.
No, I'm writing it through my mobile phone.
Okay, you tell the number.
94.
Huh?
9438.
9438. Yes.
00.
00.
24.
24.
Yes, my lord.
Yes.
2473.
2473.
Yes, my lord.
2473. Mr. Sharma will make a call to you. Okay.
Okay.
Yes.
My obligement.
Yes.
121.
Yes. 121.
Notice was issued to open number 2 lots.
Notice sufficient. Who is for petitioner? This is the difficulty. Once interim order is there, then all these things happens. Nobody comes also. None appears for the petitioner. In the present case, the interim order dated 4/7/2023 continuing, and the matter has been adjourned time to time. In the interest of justice, adjourn the matter to such day. It's made clear that on the next date appearing, if the petitioner doesn't appear, the interim order passed on 4/7/2023 shall be vacated. Please.
What's it posted to?
But he'll give it after 2 weeks. Yes. 16. Yes. 116. Anybody came? 116. Yes.
This is.
I am on virtual mode.
Okay. Mr. Kedia. Yes, Mr. Kedia, you are appearing. He says that he's covered.
Is covered, madam.
Show me that SLP. Show me that SLP.
Yes, madam. Judgment of this honorable court by passed by my lord.
Yes, Mr. Kedia, what are you saying?
Yeah. Your lordship, no, your lordship, your lordship, it may be taken up.
He's saying
May be taken up on Monday. Your senior standing counsel will appear in this case.
Every time. This is the 4th occasion, my lord. On 4th occasion,
I'm telling the
covered matter. They have lost in apex court.
It will appear on Monday.
No, Mr. Kedia, there is opposition to that. Can you come tomorrow?
In a senior standing will be appearing in this case.
It's all right. Tell him to come tomorrow because there is an opposition. He has been mentioning this matter. They are directly covered by my judgment, which has been challenged in the Supreme Court, and SLP is dismissed.
He knows about it and he deliberately avoids it.
It's all right. Tomorrow? Let it be tomorrow. You tell.
Friday, your lordship, in Friday it may be taken up. Friday. No, Friday, your lordship. He won't be there, your lordship. He'll be available on Friday.
Any day
you are choosing a date.
See, any day you choose, he will not be available on that day. So better that come tomorrow.
Tomorrow, man.
Tomorrow. Come tomorrow at 2 o'clock, no problem.
Yes.
Okay.
2 o'clock, okay?
2 o'clock, my lordship. Kindly specifically fix it with your
2
lordship.
o'clock. 2 o'clock.
My most humble submission, lordship may fix it at 2 o'clock.
2 o'clock tomorrow.
My lord.
2 o'clock tomorrow.
Yeah, oblige, your lordship.
Yes.
Your lordship. Oblige, your lordship. Thank you, your lordship.
Next.
122.
122, my lord, kind permission, my lord. I am in VC, my lord.
Yes, yes.
Yes, my lord, kindly see, my lord, your lordship was sent the matter for mediation. Flag A, the report is there. Mediation has been failed.
Failed.
Well, so I filed an IA 2440. This is not in lordship board, but it has been court master. Kindly see IA 2440 of 2024.
Who is appearing for the opposite party?
Opposite state is the Miller contesting party, and also opposite party 2 is appearing also.
What did he say?
I have filed the copy. I have sought the copy, amendment, I have brought the charge sheet on record. Your Lordship may kindly allow the amendment so that it will be heard on
Your
merit.
IA is bigger than the main petition.
I have taken some legal ground.
You file it, then I'll allow it.
Yes.
Okay, I'll allow it. Mr. Mishra and counsel for the petitioner submits that the mediation in this case has failed. Therefore, the matter needs to be heard. Mediation has failed. The High Court Mediation Center by the report dated 26/7/2024 has placed on record the report which indicates that despite efforts, mediation could not be successful. The matter needs to be heard on merits. The petitioner has moved an application seeking what are you seeking?
Amendment to my original application, bringing the charge sheet on record.
Application being IA number 2440 of 2024, seeking
amendment of the application.
Amendment to the main main petition. For the reasons stated in the application, the IA is allowed. Amendment, the petitioner is permitted to file consolidated petition. Lease the matter for this. Okay.
By next week, within 7 days, I'll file the amendment consolidated.
I have already received the consolidated petition.
Yes, you let him file.
Allow him to receive the consolidated.
No. IA. Consolidated, not filed. I'll file in 7 days. Your Lordship may call.
Entry order to continue. Yes.
Grateful.
Short date may be fixed.
Yes,
madam.
123. Yes.
May I please close? In this case, my lord, I am appearing for the opposite party number 2, my lord.
Yes.
Last week I appeared, my lord, to period for 7 days time to file objection, my lord.
7 days time to
file objection, my lord, to the.
Who is appearing for?
My lord, I have
Yes. So entered appearance for opposite party number 2 and 6. One attempt to file response. Lease the matter.
Can it do next week?
124. Interim order, if any, continue.
Objection.
124. Yes. Yes, who is appearing for the same Bangalore thing?
The Bangalore case, ma'am.
Yes. Yes. You have some any instruction?
That's
more ଥିଲା ମୁଁ କହିଲି ଶୀତ ହେଇ ପଡି କଣ ମୁଁ କରିବି
Outside what he told is a privileged communication. It's completely a privileged communication. No cognizance can be taken to that.
This is not doctor in the pinch. Very bad.
Yes. Are you ready or you want? Yes.
Short the fact is,
I know. I remember that. Yes. You were the you and your senior officer.
Yes.
Both of came for the investigation purpose here.
Yes.
And you had gone to find out apprehend one of the accused.
Yes.
While coming, you were apprehended along with ganja.
Holding 4 kg and
4 kg and
the accused who was holding that ganja, when I seized that, then it's such a coincidence. The local police was there. I don't know if it's a coincidence or it was not some kind of connection. Then I was arrested, and there has been communication thereafter. In fact, the local SP, who is a friend of the SP under whom I am working, same batch IPS officer, there was communication, and after the communication, it got revealed that yes, he was the personal reply. For the purpose of finding out the very root of the ganja transaction in Bangalore. And while finding out the root of ganja transaction in Bangalore, he was caught. And I'm immune under section 69 of the Act itself. Not to kindly see the Act.
NDPS. NDPS. Easy हो ना पड़ेगा. Yes. 69.
69, 69.
Yes. Yes.
No suit, prosecution, or other legal proceedings shall lie against the central government or a state government or any officer of the central government or of the state government or any other person exercising any power or discharging any function or performing any duty under this act for anything in good faith. done or
69,
intended to be
69
done.
आपको NDPS है.
Yes, NDPS.
Newly amended provision or what?
Right?
It's the amended provision.
Now, section 69 of your NDPS Act.
No, 68 is the repeal and saving.
69.
69.
That is the last provision. Repeal and provision. Repeal and saving is the last provision.
No, 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 madam.
NDPS.
No. Miscellaneous. Chapter VI. Chapter VI.
Acha, rules. Acha, sorry. Rules. Yes. Yes.
It is chapter Roman
Yes,
6,
yes.
correct?
Yes, 69. Yes.
Miscellaneous.
Protection. Next.
Yes.
Yes. No
No
suit,
suit.
prosecution or other legal proceeding. Shall
Shall
lie
lie against the central government or the state government or any officer of the central government or of the state government or any other person exercising any powers or discharging any functions or performing any duties under this act for anything in good faith done or intended to be done under this act or any rule or order made thereunder.
Yes.
And this is one color. Secondly, color, in fact, they are raising eyebrow as to why did I not come and arrest without informing the local police. There may be procedural information, but it doesn't matter. But Lordship, can we say section 48 of the CRPC?
Yes. Yes.
A police officer may, for the purpose of arresting without warrant any person whom he is authorized to arrest, pursue such person into any place in India. Correct? People, there are two people admitted, Himala, their own confession, that they have been taking ganja from this place, and thereafter they are selling it in Bangalore, near a college.
You are saying I have done it in good faith
Of course,
and I have not followed the procedure.
well, the entire procedure that is sought to be followed, my lad. The courts in Bangalore granted permission to go for, my lad,
Local procedure.
they say local police procedure. They are saying that I should have informed the local police prior to the apprehending him. Hello, why?
What was your accompanying police officer were doing? Other police officer, those who had come with you, what were they doing?
4 people, there are 3 arrested. 3 were there, they were arrested. And there are another 4 people, they were standing half a kilometer away. So that on getting a signal, they would come. But when the other people, they could not get any signal. Then they came after 1 hour, a couple of hours. And then they got information from the local people that we have been carried to the police station. Then went to the police station, found us, they arrested.
Yes.
Then if this happens, well,
You are the only police officer.
yes.
Yes.
Well, if this happens, well, then how can the route be unearthed?
Yes. What is the stage?
But now charge sheet has been submitted.
Charge sheet has already been submitted.
Only charge sheet is done.
Yes.
Right. Not against the petitioner, my lord, against others, my lord.
What is it?
Against the petitioner and others, my lord, some others.
Of course. One was Millet who was going to translate because I was a non-Odia, I'm a Kannadi.
Sam Kumar, my lord, he has not
And
come.
there was another gentleman who.
Why don't you argue all these points before
Framing
the court
charge,
of
my lord.
framing charges?
That is not true, my lord.
Why? That is a judgment of the honorable.
Look,
Supreme Court.
you are not facing trial, you are arguing charge.
But I have my own experience in so many courts. When we are to move an application for discharge, what do the courts do there? I have got up till experience with the Not a single court ever has passed an order of discharge. My own experience.
That may not be a ground for
That happens as a routine. It's a rule of thumb, nobody, with due respect, in the lower judiciary, wants to take up the responsibility of passing an order of discharge. Nobody. Despite me showing number of.
Because when you read the
69.
69,
Yes.
just read it once again.
Yes.
You apparently you can get the benefit of 69,
But then
but the expression used here is no suit, prosecution or other
legal
legal
proceeding. Legal proceeding is
proceeding
there.
shall lie.
Yes.
So the prosecution means the prosecution will start after the framing of trial starts.
So
Basically,
proceeding, in fact, yes.
So if you emphasize the word prosecution, it's ideal that you should argue at the
when I have been able to satisfy your lordship from the material available, and also there has been communication from the DG police that yes, he has been there on duty to
Yes.
find out.
Where is that? Where is that letter of superintendent? This is, I think, 6.
What should we see?
6.
And next are 6 and 7. At pages 6.
Have you filed the translated copy? Translated copy is there.
Lordship will see
6. Yes.
page 61.
Hmm.
That is the one in Kannadi.
No,
The
6.
translated
Come to page 66.
Yes. But submitting of special submission, Mala. I mean, the subject. Submitting of special report with respect to the act of registration of case. Detention by Sarangada police station of Odisha state of Sri Anand, the petitioner, Mala. CHC 588 of Jigani police station.
You had gone to Orissa.
Yes,
State
to trace
traced
out
out.
the accused and articles of the NDPS. Then Lordship will see, Lordship allow me to read the entire. In reference to the above mentioned subject and reference, it is submitted before you, your esteemed authority, that on 10th of October 2023, at about 4 p.m. in the evening, so-and-so Savna Yasin so-and-so police sub-inspector Jigani police station received specific information that some 3 persons had brought ganja in a bag and were trying to sell it near Aishwarya layout at Kopa Gate within the limits of Jigani police station, which she entered in the station diary. And after informing her senior officials about the information, obtained permission from the Deputy Superintendent of Police, Anekal substation for conducting raid, and then summoned the Panchayatdars and after informing them, conducted raid along with Panchayatdars and police personnel and apprehended Sujit Raut, son of so-and-so, Manoj Damani, aged so-and-so, scheduled caste, working in so-and-so, then 3 is Khageshwar Nayak, son of so-and-so, doing plumbing work, and Taluk police station, so-and-so Malad, state of Orissa, and seized 10 kg 70 grams of ganja, and has taken up investigation by registering a case in Digani police station, crime number so-and-so, under section 20, clause B of the NDPS Act. Continuing the investigation in the case, the station house officer inquired the accused number 1 in the said case, Sujit Raut, son of so-and-so, in district Orissa, and obtained his self-statement. And the accused in his self-statement stated that he purchased 10 kg of ganja from Naresh Pradhan and Subhas Pradhan of Orissa state and brought the same to Karnataka state and sold them illegally, which was proved during the course of investigation. And in this background, Naresh Pradhan and Subhas Pradhan were considered as an accused and submitted report to the Honorable 3rd ACJ and JFC Court, Anekal Town, seeking permission to continue investigation. Honorable ACJ until originally informed that the records have already been forwarded to the trial court and report was submitted in the Honorable Court number 8 of the Additional District and Sway Court, Bangalore Rural Court on the same day, that is 30th of October 2023, and the Honorable Court has granted permission on 1st of November 2023. A special team was formed to trace the accused in this case, namely Naresh Pradhan and Subhas Pradhan. And the IO submitted proposal to the district police office seeking for interstate permit letter for the special team to go to another state. On the basis of the proposal submitted by the IO, interstate permit letter was issued by this office to the special team of personnel of Jigani police station, namely Appaji, Anand.
This is accused. Anand is accused.
Yes, Channa Vasaba, some Sidhangi, and Dipu to go to Odisha. The CDR details of the accused Naresh Pradhan were already collected during the course of investigation in the case, and on the basis of the information gathered from the said CDR, a person named Shaman of Ankel, who was acquainted with Naresh Pradhan, was traced And in his statement, Sham stated that he has been seen Naresh Pradhan and can identify him, that he knew the native place of Naresh Pradhan. He was instructed to assist the special team. And Sri Jayant, who is a translator and having knowledge.
Come to page 71, huh? 71.
Yes, correct.
Accordingly, Sri Anand.
Anand.
And the information.
Sam and translator Jayant came to Sarangada at early hours on 11th of November. And the remaining remainders of the team, Appaji so-and-so, were asked to remain stationed at a distance of about 1 kilometer and to reach the spot immediately on receiving information and are waiting for the accused. On 1st of November at about 12:30 p.m. in the afternoon, accused Naresh and Subhas came along with bags containing ganja to this place and near Sarangada. And the informant, Sri Sam, identified them and informed to Sri Anand. And Sri Anand, Sri Sam, Sri Jayant, informed Sri Appaji, the other team members to come near Chanchansal. And when they went near the accused and examined the bags, the patrolling vehicle of Odisha State Sarangada police came near the spot. The accused Subhas viewed the 2 ganja bags available with him and ran away. And when Naresh too tried to run, Anand himself chased and apprehended him. By that time, the personnel of Odisha State Sarangada police station, who had come near the spot, took Sri Anand, the informant Sham, translator Jayant, and the accused Naresh into the custody, and also seized the mobile phones of the said person so that they do not contact anybody, and took them to Sarangada police station. When Appaji and other personnel who were stationed at a distance of 1 kilometer away came near the spot, they found that the mobile phones of so-and-so were switched off. The Appaji communicated with the locals, and by that time they reached the police station, it was evening. By that time, Sarangada police station personnel sent the photo and identity of Sri Anand to their higher official Sri Subhendra Kumar Patra. And Sri Subhendra Kumar Patra sent the police identity card of Sri Anand to his batch of Karnataka IPS officer, Sri Roshan Jagdish, DCP at 4:30 p.m. in the evening. And he forwarded the same to my official mobile number so-and-so. Now, after ascertaining all the information by 4:58 p.m. in the evening, I not only informed him that they had obtained passport from our office and then proceeded for investigation, but also forwarded the passport copy issued by this office through WhatsApp and requested him to forward the same to the SP. Further, I also obtained the mobile number of the SP and contacted him and informed that the personnel who were detained and had obtained passport from our office and had come there for investigation.
Yes.
But in view of the reason that the said information was not provided to the local police at 6:20 p.m. in the evening, case was registered against Anand of the Jigani police station by Odisha Sarangada police in the crime case number so-and-so.
Yes.
Then, Lakshmi, can skip over and come to page 74.
Yes.
Well, the para which is continuing from the previous page.
Yes.
About 6 lines, and even though the police identity card and interstate permit letter were produced, have wrongfully registered by the case by the so-and-so against Sri Anand of Jigani police station, informant Sri Sham and translator Sri Jayant, in view of the reason that no information was given to the local police station. Sri Anand of Jigani police station is currently in judicial custody in Baliguda jail of Odisha state.
This was taken into consideration by the police while investigation. This letter?
No. No.
My lord, the occurrence have been taken place, my lord, on 1/11/23, my lord. This letter, my lord, written on 3/11/2023, my lord.
1/11?
2 days after, my lord.
2 days.
2
But
days after.
the investigation, why this is not taken into consideration?
Whether they have given or not, that is
No, this is communication police to police.
My lord.
Superintendent of police Bangalore to your superintendent.
No, my lord. This my lord letter communicated to Director General of Police, Inspector General of Police, Karnataka State, Bangalore.
No, but it was informed to you.
No, my lord.
Yes.
Here, my lord, mentioned that Director General of Police and Inspector General of Police, Karnataka, Bangalore. The SP, my lord.
This is the internal communication between your.
The SP and the DG Police of Karnataka.
Was it communicated to police?
Well, this was communicated and Lakshmi, just saw when I read it, that there was a communication from the SP of this place to SP of that place.
No, kindly come to 75. Come to page 75.
Yes.
See, copy of the for kind information.
Correct.
Again, Bangalore. If you don't give this copy to the local police,
Well, the local police has been informed that is the ballot that is there inside. I read it to the Lordship ballot.
where?
And as 7 also another letter, my lord, 27/6, 9/11/23.
They use the new two, I am sitting down. You are never doing this when you are a petitioner for the side. Counsel for the side. Lordship will see here.
You show me that this letter was communicated somehow to the Orissa police.
But this particular aspect which I read out to Lordship, that the local SP is known to the SP who is a friend of his, and he informed him. Lordship will find that.
Nee, even 76, page 76, come to 76.
Just read out.
This is the internal communication about in your this thing.
From here only I am friend of Lordship. Well, at page 72.
70?
72 million.
Yes.
Last para. Shri Appaji ASI communicated with the localities, and by the time they reached the police station, it was evening. By that time, Saragada police station personnel sent the photo and identity card of Shri Anand to their higher officials, Suvendu Kumar Patro. And Shri Suvendu Kumar Patro sent the police identity card to Shri Anand, to his batches Karnataka IPS officer, the Roshan Jagdish Belagavi DCP at about 4:30 PM in the evening, and he forwarded the copy same to the official mobile number so and so. After ascertaining all the information by 4:58 PM in the evening, I not only informed him that they had obtained passport from our office and then proceeded for investigation, but also forwarded the passport copy issued by this office through WhatsApp. So all they are correct.
And requested him to forward the same to the SP.
Yes.
Further, they obtained the mobile number of SP and contacted him and from all. Is the informal way they have intimated, not in the formal way.
Normally,
these letters should have been communicated to the local police so that it could have been formed part of the charge sheet.
should have been, but
Mobile communication, all these things are not on record.
it is known. Now that's not known. But merely because they want to, they have furnished the charge sheet. I mean, let me rephrase it. Before my lad, after, well, at the time of investigation, when they are investigating into the aspect, should they not take into consideration all these aspects which find place here?
Yes.
And now also, my lad.
No, what is the difficulty which I am facing right now? What is running in my mind? No, you explain that. What is running in my mind is you are relying upon certain documents which are not the form part of the charge sheet. At this stage, can I go into all these things? This may be your defense. Can I go into all these documents which are not form part of document, part of the charge sheet and quash it?
No, this is what is.
Maybe your defense, maybe correct, you 100% correct.
Lordship, just in the last week, the Honorable Supreme Court delivered the judgment. What? It is against Pillar under the Pillar that money laundering.
PMLA.
No. Not that Republican law the money laundering act.
Prevention of money.
Yes. In that act, under that act, investigation was going on. During investigation, they seized materials. And what the investigators did was, the materials which are against the accused, they relied upon those materials, and the materials which were in favor of the accused, conveniently keeping with them. And even they were not reflecting that in the seizure list, and they were not handing it over to the accused.
No, if the police had seized it, ignore some document, I can understand. It was not born on the record at all. Yes.
If they mention in the Caesar list, then we can know that yes, it has been changed. If there is no mention in the Caesar list, then there is no Caesar presumption.
No,
But Supreme Court said, why are you withholding these documents with you? Well, last week only judgment has come.
no, where have you said? Therefore, I am saying, where have you said that these documents were communicated to them? You yourself has kept it. This is the internal communication between your DG and your SP.
Now, after I filed the case, after I approved this honorable court, was it not the duty, my lord, for them to inform this local police, and after filing this case, my lord, the charge sheet was submitted. But it is not that I am not taking them by surprise by filing a document.
173.8 is open or what?
No, my lord. Charge sheet submitted, my lord. Charge sheet submitted.
Just see. These documents would have been taken into consideration if see, at the highest level, this is being
keeping investigation open. This case 176 subclause 8 CRPC. Other actions are pending in the further investigation.
Then I'll have to give a direction.
Yes.
To move further investigation, taking into consideration these aspects.
Exactly.
These aspects, see, these are the communication between. Try to appreciate one thing.
Since my lord, against this petitioner, my lord, this petitioner and two others, my lord, charge sheet has already been submitted. Cognizance has already been taken against this petitioner, my lord. And subsequent, my lord, evidence, my lord, they are gathering, my lord, whether the other persons are available and they are named there, whether they are the accused person or they have named the Subhas and another person, my lord, Orissa, my lord. They are not named, not found person in the FIR, my lord, in this present case. But another thing, my lord, this petitioner, my lord, mere my lord, head constable, he is not authorized under NDPS Act to search and seizure and arrest the accused, my lord. How can he, my lord, conducting the investigation and he has cut a red-handed while holding 4 kg ganja, my lord? And he would have, first of all, he would have informed the local police and local SP that we are coming from Karnataka from these cases, my lord. They are not followed the due procedure of law, my lord. And they have been, my lord, while trying to go up in a bus, my lord, police patrolling, my lord, officers.
Where is the charge sheet?
Charge sheet, my lord.
Have you placed it on record, charge sheet?
No, my lord. Charge sheet with me, my lord.
So
yes,
tell me whether you have shared those things. Have you gone into all these aspects in the charge sheet?
There are my lord.
No.
Letters, my lord,
whatever you are arguing, all these things has been dealt with
by
by
the
the police.
That is there. One sheet.
In the charge sheet.
Charge sheet, one sheet.
Now, what have you said in charge sheet? He was a police officer.
No, my lord, that is my submission, my lord. The constable, he is a head constable, my lord. The petitioner is head constable, my lord. He has not been authorized to investigate, search and seizure everything, my lord. He is not a police officer, my lord. He is mere constable, my lord. Head constable, my lord. He has accompanied with the other officers, my lord. He would have with them, my lord.
Appaji.
My lord, Appaji is SI, my lord. Earlier, my lord, the SI not authorized for conducting investigation under NDPS Act, my lord. How this constable, my lord? He is not authorized, my lord. That is the law, my lord. And my lord, since cognizance already been taken, my lord.
The problem is, even if he is not authorized,
my lord,
the team of the police personnel were officially came from Karnataka to
they have not informed the local police, my lord. They have to inform the local SP, my lord. Where they giving producing their documents, my lord. They have not produced the concerned SP or local police, my lord. So, my lord, it itself, my lord, they are integrity doubtful, my lord. They came here for the purpose of, my lord, smuggling ganja, my lord. That is our submission, my lord. That may be recorded, my lord. Dispose of the case, my lord.
Yes.
My lord,
he constable, my lord. How can, my lord, he is search, my lord?
Any police officer from Odisha goes outside, will have the same fate. This is unfortunate that such a state.
No, my lord. That is, my lord, procedural law, my lord. This, my lord, I am giving a judgment, my lord, on our
yes.
When our chief justice, Dr. S. Murali, that Delhi, my lord, he has given, my lord, the judgment.
Then you file written submission.
My lord.
Give it.
My lord.
You may kindly say Annex 3.
3. Yes. Yes.
Annex 3 at page 27.
27. Yes.
The Karnataka State Police order number so passport for police officers going outside the state, district Bangalore Rural District, deputing Appaji Anand, Parviz Khan, Channa Vasava, Gurraj, and Dipu.
That's what I wondering whether in the investigation which is carried out by the police,
They have not.
whether all these things has been taken care of, dealt with.
1 second, madam. These are the documents I have filed in my application. And these are filed, madam, on 24th of January 2024. Lordship, may kindly see when is the charge sheet submitted.
Yes.
The charge sheet was submitted, madam. For that,
No, come to the page 19. Page 19. The FIR is registered on Bangalore FIR.
One
or 1010. Bangalore FIR 1010. Okay. Then 26 you came for that. Where is your FIR? FIR
111.
111.
111.
Which page is that?
Madam, Annex 5 at page, madam, 30. 30.
Yes. Yes.
But when everything is there, madam.
He got the bail?
No. No, I'm on bail. I'm on bail.
Since 37 is not bar for that, isn't it? Granted. I was opposing in the bail application of this petitioner, I was opposing, my lord. And other coordinated bench, my lord. Since 37 is not bar for that, isn't it? This one granted bail.
Madam, can they shut their eyes to section 69? Well, if my landed friend submission that I am incompetent to seize, then it is the accused in that case, he can get the benefit. But if I am authorized by my authority.
Show me some judgment which can give me the, this thing to consider the document which are not part of the charge sheet at this stage.
That state me I can. Well,
Wrong, right, whatever. The documents which are not part of the part of the charge sheet can be taken into consideration at this stage and quash the.
Yes, I will.
And you file the charge sheet.
That is a judgment of.
Because your entire case is revolving around a couple of documents.
Yes.
Which is germinated there in Karnataka. Somehow it was officially not communicated to the communicated or not, and if at all it's not communicated. Yes. Yes.
Yes, sir. Yes, just communicated through mail.
Mail. You place those things on the top. If see, what is running in my mind is if these documents were supposed communicated,
yes,
it was obligatory under law,
yes,
for the police,
yes,
to go into all this document in the charge sheet stage in view of 69.
Exactly.
In view of 69.
Exactly.
If they haven't done, 173(8) is open.
Yes.
They have to do it.
Yes.
Because 69 is a statutory protection. Statutory protection. If it is not communicated,
yes,
then you have to tell me if those documents are not form part of the record, yes, whether I can rely upon those documents at this stage or not. These are the two issues.
Yes.
Flagged.
Well,
Flagged. After 1 week. Least after 1 week, additional document, whatever you want.
yes. Well,
Part heard, and written submission, both of you bring it.
Let this trial not proceed against him, madam, in the meanwhile.
Next week I'm keeping it. Why? See, then again I'll have to hear everything. Now I have everything is there in mind.
Yes.
So better that you should
Well, what
conclude it.
because I am short of information. I was trying to contact the local lawyer. I could not. It was only 2 days.
I'm putting it, I'll tell you, I'm putting it in 17 or 18.
Blood, I'm at your lordship place on that day. 18th.
Then you tell me on 20th.
I'll be back on 19th. Lordship, keep it to 25th. 25th.
20?
4th or 25th.
24.
24.
Before I forget.
Yes.
Before I forget.
Well, I just.
24th, 25th, let it be 25th. 25th. 24th, a couple of matters are already listed.
It's a time at 3 p.m.
3 p.m. 3 p.m. And before I forget, you file it,
Yes,
written
yes.
submission and all.
Yes, yes.
Yes. Now, this is where we are.
Exactly.
Yes.
Well,
Yes.
whatever you feel that time, let the trial not proceed.
See, I'll tell you, once the stay is given, it goes on.
No, I'm.
If the pressure is on you, a pressure is on me as well to finish it.
Oral, if I move an
application,
Yes.
the same shall be considered in owing to the fact that the petition is sub judice before.
Yes.
Issue is sub judice before this one. Yes.
Like,
But don't.
but normally I don't will not take adjournment.
Generally, what happens, the one stay is there, one is relaxed.
Well, after
Oh,
becoming.
stay is going on, okay, kind of,
Well, after putting this gown, of course, I cannot take the money from the client the previous night and seek adjournment. Otherwise, with the other gown, it's okay.
You employ other gown people. Not doing that job. Anyway.
125.
May I please? Lastly, order dated 31/7/2024. Instruction. Investigation officer is directed to make necessary arrangement for recording the statement of the victim under section 164.
Yes.
Already 164 statement complied.
Sorry, I didn't follow you. I'm sorry. Yes.
Previously, order dated 31/7/2024.
Yeah.
Matter has been settled. Both ways.
Considering
But
taken place,
court directed
to make a necessary arrangement for recording of the statement of the victim and 164. What is directed to approve the investigating officer also and in such eventually the duty officer shall take immediate steps for recording of the statement of 164. Yes, 164 statement recorded.
Recorded, already recorded.
Yes. Yes.
In 164, that victim stated that Amo Gramoro, Raman Khan, saw more of Remo Samporoka, Sariko Samporoka.
What are you seeking here?
Matter has been already settled. Joint affidavit has already been deposited.
164, what does she say?
She stated that କନ୍ୟା ଜନ୍ମ ହେବା ପରେ ମୋ ଘର ଲୋକ ରେହମାନର ଘର ଲୋକ ରେହମାନ ବୋଲି ପିଟିସନର ମ୍ୟାରେଡ୍ ଘର ଲୋକ ବସି ଗୋଟେ ମିଟିଂ କରିଥିଲେ ତାପରେ ଆମ ମଧ୍ୟରେ ଆପୋଷ ବୁଝାମଣା ହୋଇଯାଇଥିଲା ରେହମାନ ତାର ଲୋକ ମୋର ଝିଅର ଭରଣ ପୋଷଣ ପାଇଁ ଟୋଟାଲ 8 ଲକ୍ଷ ଟଙ୍କା ଦେଇଥିଲେ 3 ଲକ୍ଷ ଟଙ୍କା ଝିଅ ନାମରେ
Bring all of them. Bring all of them, I'll quash it. Bring the accused here.
Already previously present in person. After they were appear in person.
It's all right. Appear that
Thereafter,
which order they have appeared? Where is that order? Appearance. I didn't see.
Yes, madam.
Which portion of that order?
The informant and the victim do not want to proceed further in the matter. He further contend that the matter has been amicably settled.
You show me where they have appeared in this order. Then I'll go and ask the coordinate bench.
Your Lordship, they were I am appearing on behalf of opposition 2 and 3.
Where in the proceedings show me?
Yes, Your Lordship,
bring them.
I clarify, Your Lordships.
before this honorable court, the matter was listed. And at that time, they were appear.
I understand it. Where from I'll get it from record, you tell me. Where from the record I'll get that. Yes. Why arguing these things? You bring them, I'll quash it.
Next day.
You tell me that tomorrow, day after, you tell me. 13th. Okay. Friday. You bring them because the court has only said that let the 164 statement of the victim should be recorded. Now it is recorded. She says that yes, we have settled the dispute.
Also, deposit.
Whatever the money is paid, 8 lakh rupees is paid, whatever. So on that ground, I'll quash. Let all of them be present here. Yes.
Petitioner, all the.
Yes. Next.
126. Final report has been filed on 1/9/2024, my lord. And only I have some time to attend the final report.
Final report? What are you seeking? Oh, the final report is there, then you challenge it. What is the offense?
17 and 34, my lord.
Yes. What do you say, sir? Charge sheet filed.
But that instruction is not here.
Yes.
And report has been filed on 1/9/2024, indicating that it is a false case, my lord. I have some time to.
It's a false case, they file report. Then what is the question of quashing? Unless the complainant files a protest petition, whatever happens. Right on. The present petition, the petitioner filed the present petition seeking quashing of the FIR. 31/1/2024. What 31/1/24? Acha, FIR number so and so. In the meantime, after investigation, the final form has been submitted by the police on
1/9/2024.
1/9/2024. Therefore, the land counsel for the petition seeks to withdraw this petition. Accordingly, the petition is disposed of as withdrawn. Yes. Next.
127.
No. Ma'am, I'm tomorrow morning.
On the request of land counsel for petitioner adjourned. Yes. It will go to November last. Yes.
129.
My lord, on by Mr. Chan, kindly taken up tomorrow.
Not tomorrow. If at all, it goes to the end of the November. On the request of land counsel for the petitioner, adjourned, matter is adjourned to November last.
130.
130. I'm for opposite party number 2.
Passing of the proceeding. In the FIR itself, kindly have a glance. Time of passing, no offense is made out. FIR is lodged for 417, 493, and
charge sheet filed.
Yes. Charge sheet has already.
But time of passing, no made out.
Well, in the FIR, it might not be in the charge sheet.
But I will show the Supreme Court judgment. Charge sheet filed because of the prima facie case is not made out. So
I'll have to see the charge sheet then. If the charge sheet no case is made out, even if in the charge sheet, if in the FIR no case is made out, even after filing charge sheet, I can quash it.
Yes, Supreme Court said that.
What are you submitting?
I will place the Supreme
What is the what Supreme Court? This is the fundamental. If charge sheet FIR is not the encyclopedia of everything, FIR is filed, no case is made out, it's all right. Reading the FIR, no case is made out. Thereafter, investigation has taken place. Now the charge sheet has been filed. Now look at the charge sheet. What is the offense?
Yes, I have also gone through the charge sheet.
So tell me the charge sheet.
Yes.
From the charge sheet, no case is made out.
Yes.
You have a case.
Yes, I will start from the FIR kindly, because
Where is the charge sheet for me?
8/7/2024, they have filed charge sheet.
Where is it?
Your lordship kindly have a glance to the FIR. The FIR story is that ବାସିନ୍ଦା ମୁଁ ଆପଣଙ୍କ ଗୋଚରାର୍ଥରେ ଜଣାଉଛି କି ସାନପଦର ଗ୍ରାମର ରଶ୍ମି ରଞ୍ଜନ ମାତା ଦ ପିଟିସନର ଆକ୍ୟୁଜ ସୋ ଆଣ୍ଡ ସୋ ମାନଙ୍କୁ 2 ବର୍ଷ ହେବ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖି ଆସୁଛି 2 years. She is now 20 years. At the time of lodging FIR, she is 20 years. ଏବଂ ମୋତେ ବିଭିନ୍ନ ଜାଗା ତଥା ଓଡ଼ିଶା ବାହାରକୁ ବିଶାଖାପାଟନମ ନେଇ ହୋଟେଲରେ ରଖି ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲେ। କିନ୍ତୁ ଆଜି 15/3/2024 ଗଡ଼ି ବାଣିକିଲୋ କଲେଜରୁ ଯାଇଥିଲେ ଦିବା 11 ଘଟିକା ସମୟରେ ରଶ୍ମିରଞ୍ଜନ ମାର୍ଥା ଦ ଆକ୍ୟୁଜ ପିଟିସନର ମୋତେ କଲେଜରୁ ଡାକିକି ନେଇ ରଣପୁର କୋର୍ଟରେ ମ୍ୟାରେଜ କରିବା ନିମନ୍ତେ ଉଭୟ ଯାଇଥିଲୁ, କିନ୍ତୁ ସେଠାକୁ ମୋତେ ନ ନେଇ କୋଟଗଡ଼ ପାର୍କକୁ ବୁଲାଇବାକୁ ନେଇଥିଲେ। ସେଠାରେ ମୁଁ ପଚାରିବାରୁ ମୋତେ ଗାଡ଼ିରେ ବସାଇ କିଛି ବାଟ ଆଣିବା ପରେ ଜାଣିକି ରଖିଥିଲେ ପୂର୍ବରୁ ଯୋଜନା।
Okay, now to come to charge sheet.
161.
Charge sheet, direct charge sheet.
161 of the victim.
164 is recorded?
Yes.
164 read.
Let me.
164, let us understand.
164 8 दिन पर recorded.
Whatever, 164 is 164.
164 recorded, but he changed the version.
Whether any case is made out on the basis of 164 or not, that is the test. As of today, I can't read the FIR and say that nothing is made out. The charge 164 statement, if you said something, then a case is made out.
Supreme Court says, when after some time he has changed his version, that cannot be.
Supreme Court has said everything. Show me one judgment.
Yes,
I can ignore 164 and quash it.
She has completely changed the version.
Maybe.
Because, Supreme Court says, even if in 164, he has changed the version, so that can be looked into because of the change of version, whether it is truth or not. Medical evidence, the medical report says that Dr. Fakar she called last 2 years I have sexual.
Sir, I am not here for. This is not the final hearing. After the evidences are recorded, I am at the stage of quashing. I have to see whether prima facie case is made out or not on the basis of the charge.
Yeah.
If there is a statement under 164 CRPC, if the prosecutrix herself makes any allegation, that has to be tested in the trial. That's the simple law.
Yes.
So let us read 164.
ମୁଁ ଲକ୍ଷ୍ମୀପ୍ରିୟା ମାନସିଂ କହୁଛି ଯେ ମୁଁ ଏବଂ ରଶ୍ମିରଞ୍ଜନ ମାର୍ଥା ଗତ 3 ବର୍ଷରୁ ଥିଲି। ସେ ମୋତେ ଭଲ ପାଉଛି କହି ବାହା ହେବା ପାଇଁ କହୁଥିଲା। ସେ ମୋତେ ବିଶାଖାପାଟଣା ବୁଲିବାକୁ ନେଇଥିଲା, ମୁଁ ମନା କଲି, ମାତ୍ର ସେ ମୋ ସାଙ୍ଗରେ ବାରମ୍ବାର ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲେ। ଗତ
all these allegations are very good for bail. I don't look at it. I gave the bail. Yes. You are on bail? You are on bail? Yes.
I am serving in Navy. At all the
Read it.
ଗତ 15/3/24 ରଶ୍ମି ମୋତେ ରଣପୁର କୋର୍ଟକୁ ବାହା ହେବା ପାଇଁ କହି କୋର୍ଟକୁ ଆଣିଲେ ଓ କୋର୍ଟରେ ରଶ୍ମିଙ୍କ ଭିଣୋଇ ମୋତେ କାରରେ ବସେଇ ଆରେ କ'ଣ ଚାହୁଁଛୁ ପଚାରିଲେ। ତାପରେ ମୋତେ ରଶ୍ମି ମୋତେ ପାଟି କରି ତା ଭିଣେଇ ଗାଡ଼ିରୁ ଓହ୍ଲେଇ ସିଏ ରଶ୍ମି ମୋତେ ତଣ୍ଟି ଚିପି ମୋତେ ଜୀବନରେ ମାରିଦେବା ପାଇଁ ମୋତେ ତଣ୍ଟି ଚିପି ଟାଣିଲେ। So clearly here said Millard, against her will Millard, present petitioner committed this crime Millard when 3 years back, what that time here at his appeal says 17.
What are the offences? 376?
And POCSO Millard. At the time he was 17 years old.
3 years back.
Yes.
But see, in the FIR she said 2 years. And now 3 years. All these things should be tested in the trial.
Yes. After 8 days, 164 statement record. Out 161 statement record करके they have added these offences. And Supreme Court 164 कथा change the version and they have 376(2) and they have quashed.
It must be after conviction.
No. FIR, quashing of FIR.
It says that even 164 is there on record. I can look into FIR and quash it. Does it say?
No, yeah, even if 164, while getting her statement recorded, page 6.2 paragraph, she submitted that she knew the appellant on account of dispute with her husband. She was living with her parents. All this she has said. There was complete change in the stand of the complainant in her statement recorded under section 164 CRPC. The fact remains that parties admittedly were in relationship from 2017. Some alleged promise to marry came in 2019, from where they started having physical relations. It is also common record that it is not only the consent of the complainant, which is clearly evident, but also the parents and daughters of the complainant, as they were living. It is my case also. Parents also knows. They statement say that ଆମ ଘରେ ଆସିକି ସେ ରହୁଥିଲା, ସମ୍ପର୍କ ରଖୁଥିଲା. The same house where allegedly the appellant and the complainant were having physical relationship. From the contents of the complaint on the basis of FIR got registered, the statement got recorded by the complainant. It is evident there was no promise to marry initially when the relation between the parties started in 2017. And on these grounds, and there is a delay in lodging FIR. And the incident of 2-3 years, she is lodging FIR in after 3 years. And ତାଙ୍କ ବାପା ମା ସମସ୍ତେ କହୁଛନ୍ତି ଯେ ସେ ଆମର ଦୂର ସମ୍ପର୍କୀୟ, ଆମେ ତାଙ୍କୁ ଚିହ୍ନିଛୁ, ସେ ଆମ ଘରେ ଆସିକି ସବୁବେଳେ ବେଳେ ବେଳେ ରୁହନ୍ତି, ଆମ ପ୍ରେଜେନ୍ସରେ ବି ରୁହନ୍ତି, ସମ୍ପର୍କ ରଖନ୍ତି. The parents of the victim also stated. The victim ତାର 161 statement ରେ on the same date ସେ କହୁଛି ମୁଁ ତାଙ୍କୁ କିଛି ଦିନ ପୂର୍ବରୁ ଚିହ୍ନିଲି. ଯେ FIR ରେ କହିଲା 2 ବର୍ଷ ଆଗରୁ ଚିହ୍ନିଲି.
No, you read further in that 6.2, last 4 lines. Despite assurance, the appellant did not solemnize the court marriage. And after the marriage was solemnized in the temple, treating the appellant as the husband, they both started leading marital life, having physical relationship from January 2019 till June 2020. The appellant treated the complainant as wife. Thereafter, the appellant refused to respond to the call of calls and even marry her. This is the allegation in that case.
Yes.
Your case is different.
She has completely changed her work.
You can't read part of it.
No, I have, as appears, my lord, what he has FIR has stated, my lord, ଆଜି 15/3/24 ତାରିଖରେ ମତେ କୋର୍ଟ କୁ ଡାକିଥିଲା in the one the same thing, my lord. 15/4/24 ରେ କୋର୍ଟ କୁ ଡାକିଥିଲା.
And she added.
My lord, no, what added? Same thing, my lord.
No, that cannot be admitted as a
What is the stage? What is the stage?
Says charges filed, my lord, on 8/7/24.
Summons has been issued to court.
Better what I can do is I will direct the trial court to record the statement of the victim first.
My lord.
Because they promised to marry Surya Paswan, the power judgment. Since thereafter, they continuously that has been consistently followed as on date. And even if 376(2)(l), the Supreme Court quashed the FIR even if charge sheet filed. Even if charge sheet filed, they have categorically the 3-bench judgment of the Supreme Court says that if prima facie from the FIR and other material available on record does not make out a case, so he should not be allowed to face the rigorous of the trial. And here the petitioner, who is a Navy, working in a Navy, because the informant time and again writing to the Navy office, their office, sending all the documents.
You are already married.
No, I am not married. I am not married. But they are the relation, distance relation. And
what do you say, Mr. Rath?
Yes,
1 minute. Why are you troubling? See, there was a promise to marry and everything is all right. But he is working in a disciplinary force. Why are you writing letters to harass him?
No, let that, I have no instruction with regard to that, Miller.
Why don't you settle the dispute? Is there any chance of settlement?
Yes. That, if he is agreeable to marry Miller, then all
everywhere.
Because making false promises, he has taken and committed rape on several occasions. You marry her.
Is there any chance of settlement?
I took instruction because ଯେତେବେଳେ ରାଜି ହେଇଥିଲେ ସେତେବେଳେ କଲେନି ସେ FIR କରିଦେଲେ ସମସ୍ତଙ୍କୁ ତା ଗାଁରେ ଚାରିଆଡେ ସେ ସବୁ ପ୍ରକଟ କରିଦେଇଛି even ତା ଅଫିସକୁ ସବୁବେଳେ ଯାଉଛି ଅଫିସରେ ଏକ୍ସପ୍ଲାନେସନ ମାଗୁଛି now as on date she is sending also the letter to
the relationship is like
that. Affidavit filed by the informant. Can you have a glance? Para 6, Miller.
Objection.
Miller. And para 6. the petitioner while on bail in connection with aforesaid case has again committed serious offence for which another FIR has been registered by Jankia PS so and so for commission offence so and so.
ସିଏ 29 ତାରିଖରେ ବେଲ୍ ପାଇଁ ଆସିଥିଲା ହାଇକୋର୍ଟ ଗ୍ରାଣ୍ଟେଡ୍ ବେଲ୍ ହି ସରେଣ୍ଡର ଫଲ୍ସଲି ତା ଆଗରେ ଗୋଟେ କେସ୍ କରିଦେଲେ
Why false similar? Ordinary charge sheet file, how can you say
The
false?
problem is, I can, the best what I can do is, quashing is not possible. Best what I can do is, I will send for mediation, try and find out, because this girl is hurt, because nobody is going to marry her, because
Yes.
of the kind of things happened. So she is thinking that if I can't marry with anyone, I'll make sure that this man's life is spoiled.
ନିଜେ ଲେଖିଛନ୍ତି
FIR, I'm not,
ଗୋଟେ
don't read it, don't read it. I'm not.
ଗୋଟେ ଲାଇନ୍ ଲାଷ୍ଟ
Will
ଲାଇନ୍
you
ଶାରୀରିକ ସମ୍ପର୍କ ସହ ସେ ନିଜେ ଝିଅ ଲେଖିଛି ଶାରୀରିକ ସମ୍ପର୍କ ସହ କଥାବାର୍ତ୍ତାର ଭିଡିଓ ଅଡିଓ ମୋ ପାଖରେ ମହଜୁଦ ଅଛି the girl is right
maybe that's
she has done this video and audio and what is the meaning of doing this video audio to extract because the petitioner is working in Navy
so
to extract
you are working in Navy, that's the whole difficulty.
ସେଇପାଇଁ
I know.
she has done all
But you explore a possibility of settlement. Where are you? Where is the FIR?
FIR page 37
Where? Which area?
page 34 I read page 37
Which district? Which district is this? Which district?
Who district, Miller?
this Khordha district.
Bhubaneswar.
Bhubaneswar, yeah. Begunia PS, Khordha district.
There is also mediation center
Regard
at Khordha, Miller.
being head to the nature of allegation made against the petitioner by the opposite party number 2. I am of the considered view that there is a possibility of settlement between the parties. Mr. Ratho, Mr. SC Ratho, Learned Counsel appearing for the opposite party number 2, has also submitted that he will persuade his client to make an effort for settling the dispute. In view of the same, the parties are relegated to District Mediation Center of Bhubaneswar. The coordinator of the mediation center shall fix a date for exploring the possibility of settlement and inform the same to the parties concerned. Parties concerned awaiting the mediation report, lease the matter on settlement. Yes.
Some long date maybe even he has to take leave from Navy.
Yeah. After 4 weeks. Least it 4 weeks.
Mediation maybe after 15 days or 20 days.
Whatever.
So that he can take.
He will fix a date and intimate. Then you on VC appear and try to settle. Otherwise, your life will be spoiled unnecessarily.
And that is it. Further proceeding may be stayed because
No.
he has to appear.
You apply. See, in
Annulment.
view of the fact that the matter is already referred to mediation, the petitioner may move application before the trial court seeking an adjournment. Seeking an adjournment, awaiting the mediation. Awaiting the mediation. Yes.
131.
May I please? Yes.
Madam, I am challenging the annexure 3, madam. While the
Miscellaneous matter कितने हैं? कितने miscellaneous matter? At last. Yes. Yes, sir.
I am challenging the annexure 3. While the petitioner move on application under section 167(2) of CRPC, then the learned court below has rejected the prayer and post the matter to after conclusion the date. He has referred to it, commented the case and referred to the higher forum matter. But as per on 8/4/2024, I have while I am file and petitioner under 167(2) on that was on 132nd day. The date of arrest is 25th November 2023, madam.
Yes.
At that time, I have not the charge sheet copy, but 25th November 23.
Yes. You are in custody.
My lord.
Yes. Charge sheet filed on?
Charge sheet filed on 25th March 2024, madam.
Okay. Yes.
But
at the time of filing my petition under section 167(2), that was not taken into consideration as because that the
You are already on bail or not?
My
No.
lord?
You are on bail?
No, my lord. I am in custody till now.
Yes. The 3 cases you have against you.
My lord.
Yes.
But on his own confession, he has implemented in all 3 cases.
Yes.
You have mentioned, my lord, that the prisoner was remanded on 25/11/23, my lord.
25?
Yes.
Oh.
That is page 20 that was mentioned, my lord. Rejection order.
25/11/23.
And period of 120 days to submit the charge sheet under section 162 of CRPC was completed on 24/11/23 and the IO has submitted the charge sheet on 25/11/23. Hence, the indefeasible right to be released bail does not accrue in favor of the prisoner.
My lord, can we have lastly certified copy of the charge sheet? They have written wrong information in this rejection order, my lord.
22/3/2024.
My lord.
It is filed, huh?
My lord, kindly see when the magistrate has seen the charge sheet, 25th, my lord. 25th, my lord. He has
22nd it is filed.
My lord, but presented before the court in 25th, my lord.
Where is that?
In initial signature, my lord. Initial signature or pages, initial signature. In top.
Where is at the top? 23.
25th, my lord. Not 25th.
Yes, have you seen it?
No, I'm not.
What he says is the charge sheet is filed on 22/3/2024. It is written here, but it is presented on 25th only, 25th March.
Let me obtain the case diary, my lord, then I will.
Get the case
LCR
diary.
has already come, my lord.
LCR has come, but just check it up.
Let me
Check it
verify
up.
after the case
Give
diary.
the copy to him.
My lord.
Let it come.
After 1 week, huh?
Yes.
Yes.
No, my lord. Next week, my lord.
No, 1 week after that, so
Yes.
Already I tried with my magistrate in custody in 8 months, my lord.
Okay. What is the recovery?
Nothing has been on his own confession. He was in.
What is the recovery?
Nothing recovered from his possession.
In the FIR, what is the allegation? Recovery is
My lord.
nothing. NDPS.
No, my lord.
395.
395 page.
That's what I'm asking. Nothing. Why are you saying nothing? There must be some allegation.
My lord, on his own confession, while he is in another case, he has confessed that I am.
That is on merit. You are only saying that 167(2) benefit should be given to you. Because the charge sheet is filed beyond the statutory period.
My lord.
The statutory period over the 23rd and it is filed on 25th. That's what you are saying.
But presented on 25th, my lord. Not.
That's what I'm saying. Why are you confused? It should have been filed before 23rd of March.
My lord.
But it was filed on 25th. That's what he says. But in the charge sheet, it is written 22.
My lord.
But it is presented appears to be the magistrate signs at 25th.
My lord,
You might have prepared it in your office on 22nd, but you presented that to the magistrate on 25th.
But in this case, I have filed 167(2) on first. This is the second application which in challenge. But I have filed it on. I am written in my petition, but I have filed it on first of.
Let me come 1 week after, I will obtain instruction, my lord.
Not sure. 167(2) application can't be filed repeatedly. It can be only filed once.
But kindly see the LCR. It has written.
Then you are making your case worse by saying that I have filed second application. 167 application can be filed only once.
That was when withdrawn.
Next.
As per
Next.
1 week time. That's
On request agent. He will give it.